They have frozen my debtors. Now, even if my account is available for running, it is of no use if my debtors cannot deposit money there.
All right. What is the application for extension of interim order? Which application is for extension of interim order?
Can 3 is the application for
Can 3 tate order kore din? List the read petition along with the applications before the next available circuit.
No, can 2.
Yes, next.
That will be can 2. That will be can 2. Where Lordship has already passed the order is can 3. Where Lordship has already passed the order is can 3.
No. 3 is the application for extension of interim order.
3 is the application for reimposition of interim order, and 2 is the application for debtor freezing.
Mr. Bhattacharya, I am disposing of can 3. That's for reimposition of the interim order. I have extended the interim order. So can 3 I am disposing of. Yes. So I am directing read petition along with can 1 and only 2. What is can 1?
Yes. Can 1 has already been disposed of. I have received the interim order on
already been disposed of.
Yes.
All right. List the read petition along with can 2 of 2026 before the next available circuit bench. It has been submitted by Mr. Bhattacharya that can 1 of 2025 has already been disposed of. First of the learned registered circuit bench is requested to ensure that can 1 of 2025 should not be shown to be pending in the docket of the circuit bench any further.
Great.
Yes, next. Yes.
Grateful, my lord, grateful.
Time for the petitioner.
Yes.
The petitioner is denied for her family pension on the ground that she is the second wife of the deceased. This is the second round of litigation. On the first round of litigation, family pension. On the first round of litigation, there was a direction for passing reason order.
Yes.
They have passed the reason order, and they stated in the reason order is in page number 34. Page 34 the reason order. They came with a new point that in one application, the petitioner admitted that she married at the time of the illness of first wife. But
that's a void marriage.
But
that's a void marriage, sir.
That's their contention. My contention, I married after the demise of the first wife.
After demise of first wife, then petitioner being married.
So how that dispute can be decided by the authority? You have to get a declaration from the competent court.
My lord, here,
whether that's a disputed question of fact.
My lord, already district magistrate has verified the facts and issued a letter to the pensioning authority because husband of the petitioner, he was an ex-MLA, 3 times ex-MLA. 3 times ex-MLA of Jalpaiguri constituency.
No. You have admitted. You have admitted that you married
this is their allegation. No, this is their allegation. But at the time of hearing, my learned friend is here. They are repeatedly asking, show us the letter. Show us the letter. Show us the letter.
But letter of what?
To that petition, to that extent of petition, as claimed so far, the petition being preferred, but petition was not being.
First, kindly,
petition not being shown.
In 2016, first time the application was rejected at page 15.
Yes.
Thereafter, my lord, at page 34, the impugned reasoned order, I have, my lord, I can produce a printout of this letter. I have been instructed by mail.
What letter?
Letter, my lord, when the petitioner in 2016 has stated in her own handwriting that since her sister, now the other wife and the petitioner are sisters, that since her sister was physically not well and incapable, that is why the marriage took place. Yes, my lord. And at that
Where
time,
is the letter?
Kindly keeps it tomorrow. I've just received it by way of an email, my lord. I'll produce it tomorrow.
So if that is there,
That is completely false.
all right, then let the file. Let the file affidavit.
No. She's not in the
And
right
what has
position.
fallen from your lordship, my lord, the veracity of this letter, in my respectful.
Sir, this cannot be decided. If you want, I can direct filing of affidavit.
But even in affidavits, my humble submission, my lord, the
you annex
veracity
those, let them consider.
cannot be decided by the honorable writ court.
It cannot be decided. That is why I
Yes.
gave them leave, but they are
It has to be, my
refusing
lord,
to understand.
decided by the
That's the
It
difficulty.
it is the government, my lord, it is the government recognized as
Can you come to
government,
page 17,
government,
Lord?
Sir,
government.
both of you cannot argue at the same time. You have to choose which one of amongst you will argue. Both of you cannot argue at the same time for a same party.
My,
Please choose who will argue. He will argue.
my,
Please
My-
take your
my-
seat then.
Senior will have.
my.
Please decide, senior, junior.
So-
I can hear any one of you. You have to decide who will address the court. Both of you cannot argue at the same time.
So kindly come to page 17, Lordship.
Yes.
It is the document issued by the authority, respondent authority, District Magistrate Jalpaiguri, wherein after inquiry, they come with a legal year certificate, whereas the petitioner is shown as the legal year of the deceased person, Hon'BLE Roy. So this is their document, and now they come with a one petition which is not mine, because I am illiterate, lady lordship. They are saying I have written.
Sir,
in
only
my
one
own.
thing,
So
if you
affidavit
want,
may come.
if you want me to decide on this, I can give my own observations.
Let the affidavit may come from.
On affidavits, sir, please understand, there is now a dispute as to whether the marriage between you and your husband is a valid one or not. That the authorities cannot decide, I am telling you. The certificate which you are relying upon, if you want to rely upon, I can give my own observations. But after that, if you go before another forum, it might be difficult. Because I can give my observations on this. What is the effect of this certificate?
My Aadhaar card, voter card also shows the name of my deceased person.
Sir, you are not, you are refusing to understand, that's the difficulty. Aadhaar card, voter card, can it decide the legal status? Can it decide, I am asking you?
There may be
There's a dispute whether your marriage was during the subsistence of the, during the lifetime of the first wife. These are issues of fact. Please show me a decision where it has been decided by a competent court that no, you are the legal wife, your marriage was valid. These authorities cannot decide, and this certificate has been issued on the basis of your declaration. What was the basis of the district magistrate to decide on the heirship? Under what provision? That is why I told you, if you want me to give my observations, I can give my observations on this. This cannot be said to be merely because of this document, you cannot claim to be the wife of that person. That is why I was refraining myself from making these observations. That is why you have to establish your right. I'm not saying you are not the wife, but get it established before a competent forum. They also cannot decide. They will be relying upon your letter, wherein you have admitted. Now we will dispute. You might say, no, this was not issued by me.
May I, my lord,
But that will not help. They cannot decide on that. Please understand this.
may I, my lord, make one humble submission. Now, what I understand from the pleadings and submission by my learned friend, that they are not aware or they do not have that letter. I can produce a printout of that letter tomorrow, and then if they decide and if your lordship decides, they can take it to the competent court for declaration. They'll have another thing in their hand.
Otherwise, here it will be delayed.
the difficulty is the lady is about 75 years.
That's neither here nor there. Unless you can establish your status, they will not grant you pension. That's the difficulty.
2016.
If you
it was
want
already
this to be
decided.
kept pending here, I can direct them to file affidavits.
Also, one more thing, I am already enjoying the MLA pension.
That is a separate issue.
What you are enjoying, please enjoy. Nobody is disturbing you. Please enjoy. Do not make any grievance on that. What you are enjoying, you are enjoying. That's a different thing altogether.
And any observation on this,
That is
my
why,
lord, might affect that
that is what I
other pension also, my lord.
that is why I do not want to make those observations. But if you heavily rely on that, then I have to make those observations. Because I have to pass orders on that. That is why I have seen that document. After looking at that document, I am giving you this option. Now it's your choice. Tomorrow you produce that,
I will
then let
produce the
them
letter, my
decide.
lord. Yes.
Mr. Bhattacharya Lanet, addition, প্রথমে লিখুন, the petitioner claims to be the wife of one.
My lord, wife of Bacha Mohan Roy.
Bacha Mohan Roy, who retired. He retired on superannuation.
Yes.
Who retired on superannuation as a head teacher of a primary school
99.
in the Jalpaiguri district. So, step. The grievance of the petitioner is that the authorities have not extended the pensionary benefits, the family pension, have not extended the benefits of family pension in favor of the petitioner, in spite of the fact that she is the wife of the said deceased teacher. Full stop. Mr. Bhattacharjee, on an additional government period, submits that he has received an instruction through electronic mail that the petitioner, when
On my lord, a letter was received by us on
what is the
18th,
date of that letter?
18th of July 2016.
That the petitioner by letter dated 18th of July 2026 informed
The this is the district inspector of schools, primary education, Jalpaiguri.
the district inspector of schools, primary education,
Jalpaiguri.
Jalpaiguri, that she married the deceased teacher while her sister, that is the first wife of the said deceased was suffering from illness.
Yes, physical. It's like written শারীরিক ভাবে তিনি অক্ষম ছিলেন.
Was suffering from physical
Physical
ailments.
ailments.
Full stop. Mr. Bhattacharjee prays for an accommodation to supply a copy of the letter, to file a copy of the letter before this court tomorrow.
Tomorrow.
Full stop. Mr. Bhattacharjee is requested to forward a copy of that report to the letter
Yes,
to the learned advocate for the petitioner in course of this day.
great.
You can share it
Yes, yes.
through electronic mail so
Yes.
that they can
Yes.
list this matter tomorrow under the same heading.
Yes,
Yes,
I'll do
please
that.
take instructions. What do you want?
I'll do it. Great.
Item number 5.
Why? What is this matter?
Lord, the advocate record, Lord, he's in Kolkata, my Lord, he's on his legs before the principal bench, my Lord. I've been instructed to take one day until, my Lord.
Lordship,
What do you want? Cancellation of a registered deed
My Lord, kindly keeps it tomorrow, my Lord. He will do the
in
matter.
a writ petition.
There's a backstory to it, my Lord. There's a backstory to it, so far as I remember.
Whatever backstory, the ultimate story is that you want cancellation of a registered deed in a writ court. That's the ultimate prayer which you relieve, which you want.
Kindly keeps it tomorrow.
My lord, those annexes are not legible.
Annexes are not legible. Please submit the legible copies.
Petitioner, my lord, petition number, please petitioner. Item number 7, my lord. My lord, can you allow me?
Five,
Not seven.
five চলছে, five
This
চলছে।
is not item number 7. Yes,
Five children.
not on the prayer of the learned advocate for the petition list this matter tomorrow. Yes, next. Item number 6. Yes, Mr. Ghosh.
6 Millard, the respondents are served, Millard, my affidavit of service shows Millard it is delivered. There is,
Private respondent.
there is a Bose Institute,
No.
It's a autonomous body under.
What is the date
Ministry of
you have
Science and
mentioned in the
Technology.
communication letter, Mr. Ghosh?
Communication letter to কোথায়? সেটা affidavit of service কি affirm হচ্ছে? Well, let me pass over for some time, the affidavit of service is getting affirmed, Millard.
Because what do you want?
Millard, the prayer is.
State
Millard-
is the answer is
No,
no.
no state, no, state is not there. There is
Yes.
the Bose Institute, it's an autonomous body under the Ministry of Science and Technology.
Yes.
Millard, although Millard, transfer is an incidence of service, my lord, and no one
You
can.
have challenged, you are challenging the order of transfer.
My lord, for a reason. But the reason is, my lord, I am a junior technical assistant.
Where is the order of transfer, Mr.
My lord, transfer has been effectuated in 2022.
2022?
22. My lord, just a minute. My lord. My service rule says that I am a technical staff. My job is to assist a scientist. Now I have been transferred.
To a post, there is no,
There is no scientific work assigned to that station for the last 3 years. I have been posted in Darjeeling. And why I have been posted, there is a background to it. I'm not going into that. I am
but the only
repeatedly,
question is delay, Mr. Ghosh.
my lord, I have been repeatedly writing and communicating
Does
since
it
the day
cure
of
the
my
point
transfer.
of limitation?
But I've accepted the transfer. I have no other option to do. My lord, I had to join.
Oh, now you have joined.
I have joined. I
Now
have,
you want, you have made a
joined
representation.
several representations. I have written that, see, my job is to assist a scientist. Kindly post me
So now
somewhere
your prayer will be to direct them to consider
to
that.
consider so that I am posted somewhere where at least there is a project or there is a laboratory.
Who appears for the Bose Institute?
I have no idea, my lord. Here, my lord, probably
Bose Institute, here, is at Kolkata or?
Kolkata, all the, my lord, the director, registrar, and my lord, I have also, I had to make the scientist in charge of the Darjeeling campus, my lord,
But
a party.
from where this order of transfer,
Calcutta.
then
The-
Mr.
my lord, the registrar
Mr.
of
Ghosh, how
proceedings.
can you maintain this writ petition before the circuit bench?
No, my lord, I am posted in a place over here.
Can it be,
Why
can it be, can it be ground? Because what will be the jurisdiction? Because the, it's a
Well, I-
certiorari.
My lord,
It's a certiorari. It is at a place where the main respondent is situated.
yes, they have a campus in Darjeeling. There is a scientist in charge who is my reporting authority. I am reporting to him.
But the transfer order is issued by the,
No, that
from
is
Kolkata.
true, my lord, for all the central and state organizations. Transfer orders are always issued by a headquarter.
so how do you decide the point of jurisdiction?
My lord, my
Will it be that your transfer place where you are working, or will it be because it's
Well,
the official, देखिए,
well,
every
if-
constitution doesn't.
in my view, my lord, in my limited understanding, my lord, all these 3 places would have, my lord, concurrent jurisdiction. Because I am working here, I am reporting here, I am posted here, and in the event the transfer order is passed, the order will have to be effectuated here. So that probably, my lord, a part cause of action.
So according
arises.
to you, part of the cause of action has arisen
Has
here.
arisen here.
Because where is your representation?
My lord, I'll just show you.
Because now you have made a representation to transfer you from Darjeeling to any
Darjeeling.
other place.
Darjeeling to any other place, my lord. My lord, at page 102, my lord would find my transfer order. And my lord, 104 is, my lord, my last prayer, my detailed prayer, my lord, why I should be transferred. And why, my lord, continuance of my service in Darjeeling is an absolute wastage of public money. I'm doing nothing there. There is a guest house. My job is to enter
Yes,
the
because
name.
there's a distinction between 226 and 227
Yes.
with regard to the jurisdiction
Yes,
also. Part.
Yes.
Because 226 says, even if a part of the cause of action arises.
Yes.
Where is, who appears, you do not have any idea.
No idea.
Where is Mr. HON'BLE Rai? Does he know who appears? All right, I'm passing it over. Please
Yes.
see
my lord. My lord,
please
I'll-
see the affidavit of service.
Yes.
You have communicated the correct date, then I can
Yes,
take it
my
up.
lord. I'll just check up, my lord. Otherwise,
Yes,
I
Mr.
won't-
Rai. Do you have any idea who appears for Bose Institute, Kolkata?
Earlier occasion. The bench maybe, but I appear on matter,
For Bose Institute?
against them.
Yes.
They have engaged Kishore Doctor as senior. That by matter I appear before this is Doctor, but I know by this time, maybe Long days back I appeared.
জাস্টিস দত্ত মানে তো অনেক আগের কথা।
Very much.
Post Institute.
Bose Institute responded.
Transfer order passed by Bose Institute. Now the Mr. Ghosh's prayer is innocuous because he has joined the transfer post. He has made a yes, he has made a representation for consideration.
This one I want to.
But it's better,
Millard,
Mr.
kindly
Rai,
text it
always
up at 12 o'clock, Millard, I'll come back with the.
all right, pass over. Please see the affidavit of service whether you have
Yes.
mentioned the correct date.
Yes, Millard, I will.
Because what is happening, you are mentioning one date in the presentation form and another date in the communication letter. Because I am following the practice, the date which you mention in the, for enlistment, all matters are listed on that date. That is the system which I follow, so.
That should be given. Otherwise,
Yes. But in the, Mr. Rai, the problem is in the communication letters, a different date is being given, 2-3 days after that.
that is not correct.
When this matter is taken up for hearing, respondents say, yes, look, it's a date after some 1 or 2 days. But in some cases where they are having the instructions, they are not objecting to that, they are making, but the difficulty is that
Yes.
this type of innocuous matters cannot be taken up if the date is on a subsequent date.
Just call.
Mr. Ghosh, please inquire,
I will.
and please you can ask Mr. Dotto also if you have the telephone number.
Millard, I
So
will try to
If
find
he
out.
is appearing in other matters, then if he can appear,
I remember that he appeared against me.
yes, but it's long back, whether he, yes. Call the next matter.
Well, time for the statement.
My lord, I am appearing on behalf of the petitioner, my lord. My lord, may I beg to appear on behalf of the
Yes.
petitioner? Am I audible, my lord?
My lord, answering respondent is the SMC.
My lord, this is the
SMC
affidavit of
Siliguri
My lord,
Municipal
this is a very
Corporation,
short
where is
issue,
Mr.
my lord. My lord,
Where is
My lord.
Mr. Dhar?
My lord, this is the affidavit of service.
my lord, it's a very
Suspension
short issue,
order.
my lord. Am I audible?
Yes,
My lord,
yes, you are audible, visible both.
my lord. My lord, this is a case where, my lord, due to a case, I am detained in jail custody for 48 hours. And my lord, I am put in deemed suspension with effect from 21/5/2025. 21, my lord, it is, my lord, in the year of 2021. Till date, my lord, no DP, no charge yet been initiated by the authority. So, is this my humble prayer for, my lord, revoked by.
When have you
suspension
served
and
upon the
dismissal?
Siliguri Municipal Corporation?
Of July 2026, this is the service.
देखिए कम्युनिकेशन डेट कब लिखा আছে Sir, please look at the communication letter. Date is blank. How will they know? Please see your communication letter.
My lord, allow me then, in that event, allow me 2 days time, I get a fresh service for to the municipality, my lord.
Where is Mr. Dhar? Please ask Mr. Dhar to come. I'm passing it over. So please check the communication letters. Yes. Yes, next. Pass over, please, see whether Mr. Dhar is there. Yes. Yes, call the next matter.
Number 8.
Service is not completed.
Services, what is this matter?
The police election. There have 2 vehicles, one is private, another is commercial.
Any private respondent is there? What is the dispute?
Regarding my lord, petitioner have 2 vehicles, one is private. Due to financial condition down of the petitioner, private is
All right.
given to the.
Sir, because private is, if
Yes,
private
sir.
respondent is, petitioner, the learned advocate are paying for the petitioner submits that the copy of the writ petition has not been served upon the respondents,
State is represented, Your Lordship.
upon the private respondents. First petitioner is directed to serve a copy of this writ petition upon the unserved respondents and file an affidavit of service on the next date. First state is represented by its learned advocate. List this matter before the next available circuit bench.
Great.
Yes, next.
Lordship, today today only I am assigned the So I need some time, Lordship.
Yes, what do you want?
The washing of
I
the
have not
order,
received the instruction, Lordship. So today morning only it is being forwarded.
What
to
do you
me,
want? Not today.
Lordship, not today or the next circuit because very
Uh,
limited time because I have
It's a
to
very
take.
simple matter, very short matter.
Simple matter.
No, it's all right. Simple or
Then can
because just morning today I have received.
Today morning, yes.
Then kindly make it not today. Then kindly make it not today if my senior is prepared.
Day after tomorrow because the 2 days at least be required because it will go to the law section and then they will forward to the competent authority.
Mr. Agawal submits that he has not received complete instructions in this matter to establish this matter before the next level.
Lordship, kindly take up the matter.
Yes, next.
Next.
I beg to appeal with the petitioner, Lordship. Lordship, service is not effective, but I am ready with the matter. This is a transfer matter on medical ground.
Transfer on medical ground. There is no private respondent.
No, Lordship.
Why have we implemented the superintendent of police? এটা কি ঠিক ফাইল দিলেন? হোম অ্যাফেয়ার্স দেখাচ্ছে দেখুন এটা আগের ফাইলটা দিয়েছেন গাড়ির ফাইল
আমি তো
ট্রান্সফারে গাড়ির মামলা দিয়েছে Yes, who is appearing for the state? Yes, who will consider?
Lordship,
Directed to serve a copy.
School Service Commission, Lordship.
School Service
Then
Commission.
is now DI only, my lord. Oh no, School
Not
Service Commission. State আছে?
হ্যাঁ, স্টেট আছে, ডিআই আছে তো।
School Service Commission করবে তো।
No, there will be direction among the DI to form a medical board whether he, the grounds he is seeking for that is true or not.
Not been served, let them appear for the state. We'll just request them to give us a copy. All right, let two of my learned friends appear for the state. I'll
Yes,
just request them to give us a copy, my lord, if it can be disposed of here only.
but dispose of directing what? Directing whom?
That is the DI, Lordship.
So DI will do what?
Yes, DI will, he will direct it to medical board to constitute a board regarding the genuinity of his claim, Lordship, whether he is suffering for the severe sleep discs or not. After that, medical board will decide the matter.
Where is your prayer? With regard to constitution of the medical board? Where is that?
No, that I have not mentioned, Lordship. Generally, this kind of order will pass. My pair is from page 19 onwards, Lordship.
Yes, because the transfer will be considered by the School Service Commission.
Lordship.
So now, that decision, so now you want a medical opinion, formation of a medical board?
No, generally, DI did so, Lordship.
Yes, madam, what do you say? What do you say?
There is no instruction, my lord, till now so far. We did not receive the copy.
এইটা দেখো না।
The petitioner is directed to serve a copy of, you have not served the petitioner is, the learned advocate appearing for the petitioner submits that the copy of the writ petition has not been served, to stop such and such another non-ted record who usually appears for the state is present in court and is requested to appear in this matter. Later appointment be regularized by the concerned authority. Petitioner is directed to serve a copy of this writ petition upon her in course of this state.
Lordship.
Yes, tomorrow it can be taken up.
Lordship.
Tomorrow.
Yes,
School Service Commission, please serve.
Lordship, that already I served. Let the tax will become.
Yes. Next.
My lord, one indulgence in item number 7, Mr. Sudip Kumar Pal is appearing on behalf of the Jalpaiguri Municipal Corporation.
Where is he?
My lord, I'll call him immediately.
My lord, I am appearing, my lord.
Yes.
My lord, I am appearing, my lord.
SIR. SIR. Post of 11. Yes, next. 12 SIR.
And 15 of
Please, it will be called on serial. Yes, 11, 12. 13, who is appearing? Yes. What is 13? Disposed of. Yes. Next.
Number 14.
Yes.
Since 50 years back, and it's the RS report of right, that is page 16 of my petition. 2 plot 1072 and 1076, land measuring 0.
What are you challenging?
Challenging my losses, there are the losses, I see my initial and the present electric bill. Now losses kindly comes to page 19 straightway. This is the notice by the assistant engineer Courier Highway Subdivision 2. Under section 10(1) of the Highway West Bengal Highways Act, but lordship I am reading lordship. The last two paragraphs I am reading. Now therefore in exercise of power conferred under section 10(1) of the West Bengal Highways Act, all the unauthorized enclosures situated within the right of way of Pakina Road, such and such, are hereby directed to remove all the unauthorized structures and belongings of the CW roads land on and before 31st July 2026. Now, lordship, kindly see this language of the next paragraph. Failing compliance within the stipulated period, the department shall be constrained to take necessary action for removal of such encroachments as per provisions of the West Bengal Highways Act 1964 at the risk and the cost of the encroachers without any further notice. Now, lordships, I am handing over your lordships the act itself, where my lord, the section 10(1) says, my lord, the removal of the encroachers, but lordship, your lordships kindly go through the 10(2) and 10(4). My lord, it is there. If the encroachers, my lord, do not.
Madam, the stage is 10(1), removal of encroachment notice.
Yes.
There are time is specified.
But here,
So please allow me to complete.
Yes,
If within that time it is not removed, then the assistant engineer under 10(2) will forward it to the executive engineer under 10(3). At the 10(3) stage, you will be entitled to produce all materials in your support.
Yes.
That's the only stage where inquiry is permitted. So upon inquiry, an order will be passed. If it is found that there is encroachment, to remove the encroachment, that order is applicable under 10(4) before the district magistrate. So this is the scheme of, as I've understood, under the 1964 Act. So this is the first stage. So this is only the first stage. They cannot straight away demolish. So 10(2), 10(3) stage.
that is what, my lord, I am seeking before your lordship, because the language and they have threatened that they will, if they, the authority itself remove, that they cannot as per section 10(2).
Yes,
No,
madam,
no, lordship.
you want
There
to
is a-
remove without
No,
following the
no,
procedures.
lordship, no,
I
no.
record your
No.
submission that it will be following the procedures under 10(1), 10(2),
10(2), yes, lordship.
10(3).
We will follow the procedure,
That-
lordship.
that
We will
will
not
be
remove, lordship. Lordship, kindly seize the annexure, lordship, annexure number 21 to 24, lordship. There are, we have sent the notice to the 56 persons, lordship. There is an encroachment, lordship. Even the petitioners admitted that there is an encroachment, lordship. We served notice upon the 56 petitioners, lordship. Those who have
Have
the
you carried
relevant
out any demarcation exercise?
No, lordship. For
Then
now-
how do you know there is encroachment?
Lordship, in the periodical inspection, lordship, the authority has find
Show
out
me the
with the
demarcation report.
lordship, matter was served upon me yesterday, lordship, and in one day, lordship, it is not possible.
Have
for
you
me
come
to-
across any matter
Yes,
where
lordship.
before issuing the notice under 10(1), demarcation exercise has been undertaken? Please show me, give me one instance.
Demarcation has not done.
Give me
lordship, but
one
the-
instance.
But the joint survey with the BLO,
Madam, I am
lordship.
telling you,
Lordship.
madam, I am telling you from my experience is after 10(1) notice is issued, you issue repeated notices to the block land and land reforms officer to demarcate, not done.
Yes,
I
lordship.
can tell you 2, 3, 4, 6, 1 year even. Demarcation exercise not done. That's my experience in this site.
Yes, lordship.
So I can assure you, because I was presiding over this bench for 5 to 6 months. So from experience, I can tell you that demarcation has not been done. So without demarcation, you cannot decide that there is an encroachment.
But lordship, what
So you will
instruction
be
I have-
following procedures. I am recording your
Yes,
submission.
lordship, procedure is.
Ashok, the
To be given.
madam, that's at 10(3) stage. You will be getting.
Yes,
They are saying that will
That
be
is
done.
what lordship
Okay,
kindly lordship.
64 Act. You have a copy of this. Photocopy will do. This application under Article 226 of the Constitution of India. In this application under Article 226 of the Constitution of India, the petitioner has challenged a notice under Section 10 within bracket 1 of the West Bengal Highways Act 1964. First up, the learned advocate appearing for the petitioner, where have you stated which paragraph? The petitioner states that his father was the owner of a land measuring about 0.02 acres in plot number 1072 and also 0.32 acres paragraph 2. In plot number 1076 of Moja Gugumari, jail number 131, block Kuchbihar 1 in the district of Kuchbihar, and the name of the father of the petitioner was duly recorded in the RS record of rights. So the petitioner states that after the demise of his father, he has inherited the property and he is residing on the said plot of land with his family members by erecting a dwelling house thereupon. So the petitioner alleges that the petitioner states that the petitioner, madam, have you stated anywhere that you have not encroached?
No, my lord, I am not encroached. My lord, I have.
Where is your statement on oath that you have not encroached in the writ petition?
My lord, paragraph 3, I have stated the said property was enjoyed by the petitioner along with the.
No,
other
you are the owner of a particular property, but you have not encroached upon any PWD road.
There is no question of encroachment.
Owner of a land does not encroach upon adjoining a public road. What are you saying?
Particular this.
Without anything, they will not issue the notice. I was contradicting the thing with regard to that, but there is some basis of issuing these notices.
I only want.
The petitioner states, the learned advocate appearing for the petitioner submits that though the petitioner has not encroached upon any portion of the road belonging to the Public Works Department of the Government of West Bengal, a notice under a vague notice under Section 10 within bracket 1 of the West Bengal Highways Act 1964 has been issued without, which is not, without, full stop, paragraph. She submits that by the said notice, the persons whose names have been indicated in Annexure 1 to the notice dated 21/7/2026 have been directed to remove the encroachment as per the provisions of the West Bengal Highways Act 1964. First up, paragraph, the Ms. Singh Lanet, junior government advocate submits that on a query of the court, Ms. Singh Lanet, junior government advocate submits that steps have been taken by the concerned authority by issuing a notice under Section 10 within bracket 1 of the 1964 Act to remove the encroachment. Mr. further submits that the procedures laid down under Section 10 of the West Bengal Highways Act 1964 shall be scrupulously followed while removing the encroachment from the government road. First up, paragraph, Section 10 within bracket 1 of the 1964 Act states that if any person is found to have made an encroachment on any road, street, path, way or land, which is declared to be a highway under subsection 1 of section 3, or B, makes an encroachment on a highway in contravention of the provisions of section 8, or C, does not remove any encroachment on the expiry of the cancellation of any permit granted to him, the highway authority or any officer authorized by him in this behalf shall serve a notice on him requiring him to remove the encroachment and restore the highway to its original condition within the period specified in the said notice. Subsection 2 of section 10 states that if the encroachment is not removed within the time specified in the notice, the highway authority or the officer authorized under subsection 1, may make an application to an executive magistrate having jurisdiction over the area, not being the district magistrate, for removal of the encroachment and delivery of possession of the land encroached upon to the highway authority or such officer. So subsection 3 of section 10 states that such magistrate may, on receiving the application and after notice to the person, responsible for the encroachment and on taking such evidence, if any, as he thinks fit, make an order authorizing the authority or officer to recover possession and remove the encroachment in question and may, if necessary, direct the police to assist in the enforcement of the order. First up, upon going through the aforesaid provision, it is evident that the first stage for removal of encroachment is issuance of notice under section 10 within bracket 1 of the 1964 Act. First up, if, however, the said encroachment is not removed within the time limit specified in the notice issued under section 10 within bracket 1, the highway authority has to apply before the executive magistrate for removal of encroachment and delivery of possession of the land encroached upon to the highway authority or such officer. First up, subsection 3 of section 10 contemplates an adjudication to be made. First up, it is at that stage that the person responsible, it is at that stage the a notice to the person responsible for encroachment is to be issued, and upon taking evidence, an order has to be passed. First up, paragraph. In the case on hand, only a notice under section 10 within bracket 1 of the 1964 Act has been issued. First up, the learned advocate, the learned junior government advocate submits that all the steps contemplated under section 10 shall be scrupulously followed. First up, in the light of such submission, this court is not inclined to interfere with the notice under section 10 within bracket 1 of the 1964 Act at this stage. First up, with the above observations, the writ petition stands disposed of. Yes, next.
Item number 50.
SIR disposed of next.
Item number 60.
Item number 6 is our particular presentation committee mentioned that matter will be listed on
Tomorrow. Tomorrow. Have you got the information? Any private party is there?
Yes, my lord.
Private party is there?
Yes, yes.
Tomorrow.
Great.
Yes, next. On the prayer. Yes, next.
Item number 17.
But item 17, item 17, item 17, I'm for the petitioner. I'll be there physically tomorrow. Kindly take it up tomorrow. I'll be there physically. Kindly,
Mr.
Kindly
Bari,
take it up tomorrow.
is it so important that you cannot satisfy me virtually?
No, I have 2 other matters tomorrow. That's why I'm regular. I have 2 other matters for tomorrow.
All
I'll
right.
take it up tomorrow.
Tomorrow on the prayer. Yes, next.
Take it up.
Yes, Passover matter to take it. Mr. Rai, your other side has come. He has not come. Tale pore rakho. Yes, next.
The other personal matter.
Yes, yes, I'm calling. Yes, other pastoral matter, what have you found?
But I have found that the date is correctly mentioned in the foundation.
Date is correctly mentioned. And when it was served? Twenty-eighth is just yesterday. So I'm keeping it tomorrow because one day, 48 hours. What is your item number?
Item number 6.
Item number 6 at record করে নিন. Mr. Ghosh, learned advocate, appearing for the petitioner, submits that তার আগে লিখুন. Affidavit of service filed in court today is taken on record. Full stop. None appears for the respondents. Full stop. On a query of the court, Mr. Ghosh, learned advocate, in his usual fairness, submits that the respondents have received the copy of the writ petition only yesterday. বলে কালকের ডেটটা দিয়ে দিন. Full stop. In order to afford an opportunity to the respondents to contest this matter, list this matter tomorrow under the same heading. Yes.
Well, I will communicate a copy of the order through mail also.
Yes, please communicate
If the address.
The petitioner is given liberty to communicate the next date of hearing to the respondents through electronic mail.
Both student mail টা বার করে।
Mr. Ghosh, do one thing, do that at Calcutta and also the local office.
Yes, all
Have you
the
served
addresses.
upon Kolkata?
Yes, all served.
Please, electronic mail,
Yes.
please communicate.
Yes, please.
Yes. This is, what is the item number? 7. 7, Doctor.
কোনটা হচ্ছে 7 না 18 কোনটা?
So, Dhar, you are appearing.
My lord, in item 7, I am just in a quasi accommodation letter. Then we shall file a fresh notice to the respondents and this matter be kept.
All right. On the prayer tomorrow. Next.
Item number 18.
I'm on behalf of the petitioner.
Yes.
Direction for report to be filed by the SMC.
To be filed by?
SMC, Siliguri Municipal Council.
Yes, Mr. Dhar is sitting there. Yes.
Coming by the-
You have changed. When? Then who is appearing? Has he come today?
My lord, Mr. Pal is at Shiliguri.
Then please serve a notice upon him.
Again, my lord.
Upon the learned, but panel is changed. What can be done now? Panel is changed.
In this bench. So your lordship, my lord.
Only one day left. What can be done?
And there is a direction for filing report, lordship. I
Yes.
think
By the SMC.
by the SMC.
Madam, if it is for filing of the report, it might be Mr. Dhar has not prepared, I think. So he has,
आपके लिए है.
he has not prepared. So the newly engaged counsel will take a time. So I'm doing one thing, I'm keeping it in the next circuit bench. Please communicate. I'm extending the time to file the report. Today, when this matter is taken up for hearing, Mr. Dhar, I'm recording your submission. Today, when this, I'm recording your submission that you are, today, when this matter is taken up for hearing, Mr. Dhar, learned advocate, appearing for the Mr. Dhar, learned advocate, submits that he do not have any further instructions to represent the Siliguri Municipal Corporation. To stop, this court has been given to understand that Mr. Sudeep Pal, Mr. Sudeep Pal, is usually is representing the Siliguri Municipal Corporation. To stop, the learned advocate for the petitioner is directed to serve a notice. Please serve a copy also, because
Notice, my lord. Copy do they have, mine?
who have? It's with Mr. Dhar.
Already submitted to the SMC final. I'm not only submitted. But I'll give a notice, madam.
Is directed to serve a notice upon Mr. Pal in course of this week. So the time to file the report in the form of an affidavit as directed by the order dated 22nd of July 2026 is extended. When is the next circuit starting?
10th August. 10th August.
Is extended till 10th of August 2026. Full stop. List this matter. before the next available circuit bench, subject to the convenience of the honorable bench.
Great.
Ms. Singh, you are appearing.
Yes, Lordship, on behalf of
For
the state.
state is represented by the Singh, learned advocate.
Great, Lordship.
Yes.
May it please your lordship, Lord. May I address your lordship, Lord, virtually. Lord, this
Mr.
is
Banerjee, I cannot permit you to appear virtually.
my lord, I had come yesterday. I had to go back, my lord, because of my illness. I am actually under having that viral fever, which is there in. I had to come
Take
back.
rest, Mr. Banerjee.
My lord,
Why are you
client-
straining yourself?
advocate cannot take rest, my lord. Otherwise, client will be in perpetual rest. My lord,
Yes.
this is, my lord, a PF matter, my lord, in connection with certain dues of, my lord, the Longview Tea Estate in Kurseong. Now, my lord, there were, my lord, financial difficulties which this tea estate and the industry at large was facing. And therefore, my lord, a prayer was made, my lord, for grant of 72 installments. Now, 72 installments for payment was granted in terms of, my lord, the EPF's own decision based on, my lord, a one-man committee of Justice Abhay Manohar Sapre, my lord, the retired Justice of the Honorable Supreme Court, my lord, who had been appointed in order to see, my lord, that the dues situation of this part of the world, my lord, is appropriately mitigated. Now, my lord, 72 installments, my lord, we had, my lord, applied for, and we had been granted, my lord, 72 installments. Now, we started making payment, my lord, of the installment schedule. If your lordship kindly comes, my lord, to annexure P11 just once.
Page?
Page 99 of your lordship's brief.
Yes.
Now, my lord, we had made, my lord, payment, my lord, of the installment schedule. The first installment we had paid, and thereafter, my lord, kindly takes this representation, my lord, of May 28 and 26, where we have, my lord, mentioned the situation. Just what we will show your lordship, my lord, paragraph 3 onwards of the representation, just only snippets of it. Longview Tea Estate has endured an unbroken succession of adversities that have brought the company to a.
Now, Mr. Banerjee, what is the due as on this date? What is the due?
The current due, my lord, is serviced, my lord, by 72 installments, 2 of which, my lord, we have already paid. The difficulty is that because of the fact that there were adversities, we had to, my lord,
So this
apply for-
installment, Mr. Banerjee, the installment would start from which date?
Now, my lord, I have given, my lord, the breakup. If your lordship kindly sees, the installment would start from, would end, my lord, in February 2026.
Where, which page?
Now, my lord, kindly comes, my lord, Mr. Agarwal is there, my lord, he'll point out the relevant page. Just 1 second, lord.
Which page? Show me.
Sir, at page 101.
Yeah, please come, my lord.
Page 101, Lordship. 101.
Yes, 101.
We now humbly, the second last paragraph, Lordship. We now humbly request your good office to commence the payments. First installment proposed to be deposited on June 15th, subsequent to follow thereafter.
No, I am asking you the installment, the 72 installment would start from which date and till date, how much installments are due? That breakup is necessary.
Lordship, the payments, if I may, with the permission of my senior.
Yes,
this
yes,
payments is 72 installments.
Which will start from which date?
Starting from 15th June 2026. Lordship,
15th of June 2026.
and we have already deposited as 15 June and 15 July installments. Lordship.
15th June and
15th August.
15th July you have deposited.
Lordship. And 15th August, when it comes, Lordship, as per.
Please show me the order giving you liberty to pay by 72 installments. Where is that?
Please come, my lord, to page 93 of my lord's brief, my lord. Page 93 of my lord's brief.
93.
Yes.
Yes.
My lord, this is to the director, manager, Longview Tea Estate, Kurseong, written by the EPF authorities. Now, my lord, kindly come, lord, straight away, my lord, to paragraph, the paragraph which is, my lord, quoted below, para 7.
Yes.
Further, Honorable Justice Retired A.M. Sapre, former judge, the Supreme Court of India, has given the following direction to avail installment facility for liquidating the arrear dues on the order dated 1st of March 2023 in para number 7. Para 7 is quoted. Considering the directions given at para 19 of the previous order and in extension of the time therein, committee deems it fit to direct the PF department to do the following. Now, my lord, we are covered, my lord, by kindly come to the next page, Roman 1. Those tea gardens having due below 50 lakhs, 12 installments, we come to Roman 4. Those of the tea gardens having dues of above 2 crore shall pay the dues within 72 equal installments. Each installment shall be payable order before 15th day of each month. And any default made by any tea gardens in making payment of any 3 installments shall result in withdrawal of the facility and the entire balance amount shall become payable forthwith. Above directions in para 9.1 to 5 and para 7.1 to Roman 2 of the order dated 22nd July 2022 and 7th March 2023 respectively on the issue of number of installments shall be read along with other terms and conditions mentioned in the EPF circular. Further, it is informed that your establishment falls under category number 4 as per directions given the said order and as per latest due payment status. Therefore, it is once again directed to comply with the terms and conditions specified in the EPFO circular dated 11th of February 2014 and start payment of installments immediately. In case of direction not being complied with 30 days, presume that you are not interested.
So, Mr. Banerjee, technically, this order was passed in 2023.
But it was communicated, my lord, to us, my lord, much later. If your lordship kindly now, my lord, looks at the next one, our letter of May 28, 2026, Lord, Annexure P11, we have stated that this letter, that this 2023 order, we received much later owing to, Lord, some communication gap. And immediately upon getting that, we had, my lord, started making payment of the installments in terms of the said scheme. We were not sitting over, my lord, the order after getting to know that. Now, Lord, if your lordship kindly sees, I kindly come, Lord, to our representation, which we have shown your lordship, Lord, at page 99. I am taking your lordship's kind attention to, my lord, page 101.
101.
101, my lord, of your lordship's brief. Kindly come, my lord, to the second paragraph. We must respectfully explain why there has been a delay in commencing these installments. Order granting the installment facility was dispatched to the tea garden from your office. However, owing to continuous strikes, disruptions, dharnas, gheraos, and the persistent non-cooperation of office staff that have afflicted the estate throughout this period, communication was misplaced at the garden level and did not come to the knowledge of the manager of the management. This was not a case of willful disregard. It was one more consequence of the very disruptions that have plagued the estate's operations. On the contrary, the management was regularly following up with your office regarding the installment facility through its advocate, Sri so-and-so, who has been handling the company's provident fund matters for an extended period. It was only during the current strike, which commenced in mid-April 2026 and during which provident fund issues were specifically raised, that the existence of formal grant of installment facility came to light. We sincerely regret the delay and humbly request that it be viewed in the context of the extraordinary circumstances that gave rise to it. We now humbly request your good office to allow us to commence payment of installments in accordance with the installment facility granted to the company. The first installment is proposed to be deposited on June 15, 2026, with subsequent installments to follow monthly thereafter. We enclose the following in support of the request, and my lord, we did this. Number 1, 72 checks towards the monthly installments. employers undertaking undertaking executed on non-judicial stamp paper rupees 10. With regard to the bank guarantee, the company approached the State Bank of India for the issuance of a bank guarantee covering 6 months of installments amount to 67 lakhs and odd. However, a difficulty has arisen that we respectfully bring to your attention. Company's bank account has been attached by the
No, Mr.
EPFO.
Banerjee, only one thing, Mr. Banerjee, only one thing. You are supposed to make payments from 2023. Now you have started making payment of the first installment in June 2026.
But we have come
3
to know
years
of the
delay.
my lord, 2023 order. I'll tell you.
When did you come to know of this order?
This order,
When did
my
you
lord,
come to know of this order?
We came to know, my lord, immediately before writing this representation. We have stated that. My lord, on May 28, 2026, we found that this particular order came to the knowledge of the management much later. This order may have been sent, my lord, surreptitiously to a portion, my lord, of the manager there. I will tell you, lordship, there was unprecedented strike and other activities going on in the company, and the entire period during this, my lord, the laborers were on strike. For a long period, my lord, the entire functioning of the company, my lord, was jeopardized. The gardens did not work. The moment the management came to know of this order, the
Yes, what
management
do you
has
say?
sent its persons
Mr.
to the
Banerjee,
captain of
that
the
is,
facility.
it's difficult because from 2023, you are directed to pay. Now you are taking the plea of COVID. The order was 2023 after
not
COVID.
not COVID at all. My lord, not COVID
So
at all.
that is the plea you have taken in page 99.
Yes.
That
to
is the plea
explain
you have
overall
taken in page
situation. The
99
company-
also.
To explain the overall situation, kindly bear with me for a second. I can understand.
No,
I think-
that cannot be taken into consideration.
Yes, for this
because
purpose,
the
no.
order
Yes,
was
yes.
passed in 2023. It's post
Yes, yes.
COVID.
2023, COVID is a past.
Now the only
past event.
question, only question, you say that it has come to your knowledge just prior to that. That's a factual thing. Unless that is ascertained, Mr. Banerjee, it's difficult.
Now, my lord,
Or
I'll
if you
tell you,
can,
lordship, what I'll do.
Mr. Banerjee, one thing can be done. If you can deposit the entire amount starting from 2023 to 2026, that can be considered.
No, that is
What
that
would
is
be the
covered in
due?
the installment. So I'll
10
tell you,
crores.
lordship, Lord, perhaps
10
now,
crores.
kindly come, Lord, to the installment facility that we are seeking. Please come to annexure P16 just once. P16. I am in the process of furnishing a bank guarantee for 6 months also. Page 112. 112 of your lordship's brief. Please have a look, my lord, at the prayer that I am making now. And this is a prayer, my lord, which I am ready, my lord, to really stand by. Please help me, my lord, revive my industry. My lord, kindly come, my lord, at 114.
Yes.
Now, my lord, we have mentioned, my lord, how many days we have lost on account of, my lord, the gheraos and all that are happening. The garden is not being allowed to function. Even today, my lord, despite our best efforts, the garden has been put on a standstill because the laborers are not allowing, my lord, the manager and other persons to come and take charge. We are therefore requesting, my lord, only one thing.
No, what is the present position, Mr. Banerjee? Can you take charge? Are you operating?
Yes, yes, I am operating. I am operating.
Since
I can
when?
take charge from today.
You have taken charge only from today.
No, I am being
Then
prevented.
nobody knows what will happen day after tomorrow.
Nobody
knows. Again, you will be at default.
No, I will not be at default. I'll tell you, lordship, what. Lord, whatever monies had come in the meantime, we had made payment of the wages. Some part of the employees' contributions became due because of the fact that we had to service, Lord, the day-to-day wages. We thought that, Lord, because there was no money in the till, this is the 7th year running where we are facing losses. We will make up-to-date payment of, Lord, the laborers' dues. Lord, the wages we have given top priority for the purpose of, Lord, ensuring that the laborers are not, Lord, put to a perilous situation. We are not running away with
What is the present due, Mr. Banerjee? What is the present due? If that 72 installments, no, if the 72 installments are taken from 2023 till date, what would be the amount of due?
Lord, I'll tell you, Lordship, before that, Lord, I can fully appreciate what is flowing through the mind of the court.
Yes.
My Lord wants that the period during which that order had been passed and my first compliance had been recorded, that period be serviced so that I can then proceed with the installment schedule. That's what passing to your lordship's
Yes.
mind. This is what I have proposed. My lord, kindly come to 115. I'm grateful to your lordship, my lord. Fundamentally, my lord, the honorable court, my lord, and we are ad idem. Fundamentally, 115.
Yes, yes,
Please come, my lord, to the second last paragraph at 115.
yes.
Sorry, the last paragraph. We've said what is the reason here. The workers are trying to block us, which is also a fact. We are not being allowed to operate the gardens, and that is because of the hue and cry for areas. This is becoming a vicious cycle. Therefore, will not kindly see this, and I'm saying this with responsibility, all the responsibility at my command. In light of all that is set out above, we earnestly request your good office to grant the installment facility enabling liquidation of the outstanding provident fund contribution of rupees 398,16069 for the period from March 2022 to February 2026 in 72 equal monthly installments. We further request that all pending proceedings initiated to recover PF dues from the company be placed on hold.
That means, Mr. Banerjee, you want 144 installments. 72 installments from 2023. So
No,
now you
rescheduling.
want from 2022 to 2026, 72, and thereafter again 72. That's what is the total due from 2023 to till date? 72 installments. How much? How many installments? And at that rate, what would be the amount? This this amount
as far as
you have
the-
not paid, that is also on 72 installments. That cannot be allowed.
Now, my lord, I have made payment of 2 installments in terms of the 72 installment schedule which we have started.
2
That-
installments is, Mr. Banerjee, it's neither here nor there.
No, I've
2
started paying
installments is
monthly.
nothing. You are not doing charity, Mr. Banerjee.
No, definitely.
You are not
definitely.
doing charity.
Yes.
So
That-
you have to
We
come
have
out
to
with a
pay.
calculation. What? Yes. So
Yes, we
please
have
come
to
out
pay.
with a
The only thing.
calculation. What is the amount due? You have to show your bona fide by
Yes.
putting in some amount.
Yes.
By
Definitely.
saying that from today, give me another 72 installments. That
No,
cannot
some
be.
amount has
That
to
is
be
not
paid.
appreciated,
100%
Mr.
some amount
Banerjee.
has to be paid. But only one thing I'm saying.
Yes.
Only one thing. Please consider me not my predicament today. I am not
But
being
what is the
allowed-
calculation? Mr. Banerjee, please come out with the calculation first, then it can be considered.
Now, my lord, kindly look at
What
my
would
lord,
be
my
the amount?
installment schedule. Please come, my lord, to the period which I am catering. Please come to 115, the period which I am talking of.
Yes.
The liquidation is through 398, is for 398,16069. And I am
Yes.
seeking up to February 2026. I am actually seeking reconstruction of the period. I am not seeking reconstruction of the installments. I am seeking reconstruction of the period from March 2022 onwards till February 2026.
Mr. Banerjee, you have taken time from 2023 to 2026.
This period
After
I take-
taking time for 3 years, now you say, yes, I do not want to reduce the installment. Please extend, restructure. That is a very nice submission to hear, but very difficult to digest, Mr. Banerjee.
May I just
Very difficult to digest.
May I react?
Very nice thing to hear.
May I appropriately, with great respect to your lordship, your lordships are absolutely correct. Insofar as payments is concerned, payments have to be made.
Yes.
The question is, my lord, rising to the occasion to see, my
Because
lord, that they
it is
can be
after all,
practically made.
it's not your money. It's
Yes,
after all
yes.
not your money.
But it has been
Yes.
serviced for the
So-
purpose of making wages, payment of wages.
Yes.
I am not using it. There is no diversion.
Please come
here.
out, Mr. Banerjee. Please come out with a calculation. What would be the amount and how much you can put it upfront? Please come up with an calculation with regard to that.
In the meantime,
Giving
my
a
lord, I
calculation
only have a
in
humble-
advance to the
Advance to the,
advocate for the respondent authority. Be practical. Give us a suggestion which the authorities will also accept.
My lord, only I had one prayer. My lord, kindly come back, my lord, to Justice Sapre's directions just once. Why I am saying, my lord, this
Yes.
restructuring is possible. Justice Sapre had directed, this is in once the entire Kurseong
Mr.
Darjeeling
Banerjee,
sector.
please come up with the calculation. Then I will consider
No, my
how
lord,
it
the
can be
amount, my
modified.
lord,
How
knows
it can
3
be.
lakhs and odd. My lord, kindly sees the 3
Ye-
crores and odd. The amount we have mentioned.
Yes.
That's at 115.
Yes.
3 crores and odd
Yes.
covers
How
me
much
up
you
to
can?
February
How much you can
2026.
deposit, Mr. Banerjee? How much you can deposit upfront? 72 installments. it's difficult. From now,
Milord-
some part you have to pay, then it can be considered. Please
Now,
take
Milord, we have
instructions.
also made
Please come up.
payments. Milord, we have made payments, Milord, for the period August 2025 till February 2026. 25 lakhs more have been paid on July 27.
So you adjust that. No, Mr.
Mr.
Banerjee, you
Agarwal is
adjust
there.
those
Mr.
payments.
Agarwal will please adjust the amount and give my lord, the exact figure which is due till now. And then we will have to pay
Yes.
something. I can understand. Please bear with me for
Yes.
5 seconds.
So please, Mr. Banerjee, do one thing. Please make a detailed calculation, taking the adjustment. Please give a calculation to your learned friend in course of this day. I'm keeping it tomorrow.
My lord, only one thing, my lord, only one thing. My lord, with great respect.
Yes.
But
Yes.
my learned brother, one second, brother. My lord, with great respect,
Yes.
my lord. Mr. Govind Garg is the person, my lord, who is not a director of this particular organization, of the company. He is just a shareholder. Mr. Garg is being witch hunted. FIR after FIR after FIR is being filed despite this matter, my lord, being pending before the PF for their consideration for 72 installments. My lord, Mr. Garg has on the earlier occasion also, criminal prosecution has been initiated, it has been quashed. There are inter partes orders in which it has been said that a person not connected with the company should not be proceeded against. FIR after FIR has been quashed, but now a witch hunt is on. Mr. Garg, my lord, last Friday when I mentioned this matter before your lordship, PF came and took time, my lord kept the matter on Tuesday. In the meantime, on Saturday evening, from his Salt Lake or Lake Town residence, my lord, Mr. Garg was arrested. And then, my lord, on the basis of a purported FIR lodged on the 22nd of July, of which the PF had notice, but chose not to instruct its advocates when the matter was moved on Friday. As a result, my lord, if your lordship recalls, I had prayed, my lord, no coercive steps be taken. My lords have said, no, my lord, no, Mr. Banerjee, you come back on Tuesday. Since you have waited this far, you come back on Tuesday. The PF said that there was no instruction. In the meantime, the police were mobilized and Mr. Garg has been put behind bars. He's a person of acute
Now,
cardiac
Mr.
difficulties.
Banerjee, yes, you made this submission yesterday. Your learned friend says that that is from a different proceeding.
That's
because
not from a
here you are
different period.
challenging.
That's what I'm saying. My learned
Mr.
friend is wrong.
Mr. Banerjee, here you are challenging an attachment notice. So
I'm
that's the
challenging
subject
open
matter
note.
of the writ petition. So if you are entitled to, please take steps against that proceedings, because that is not before the court. This is only an order of attachment.
An
This
order of
scope is
attachment
limited
plus
only to-
my prayer, my lord, to reschedule the installments. That is also there.
Yes, that I will consider. That I will consider with regard to that arrest and other things. That's a separate story altogether. Please give a calculation to your learned friend in course of this day. I'm keeping it tomorrow. And please come up with some suggestion, some upfront payment, which might be also acceptable to the authorities.
My lord, only one thing extra. Only
Tomorrow,
one thing extra. My lord, only one
yes.
thing extra. My lord,
one point.
Yes.
So what
only
is
one
their
thing extra. Brother,
calculation?
one thing. Only
Is
one thing
there
extra.
sort of thing? Kindly come to the page
My
number
learned
80,
brother will kindly give me 1
86.
minute before he. Milord,
Kindly
I want
come to the-
Please wait for a minute. Yes, yes.
just one
Yes,
minute,
Mr.
brother.
Banerjee.
Please take, Milord,
Yes.
please take, Milord, my supplementary affidavit which I have filed in connection with this matter, my lord.
Yes,
In the
supplementary affidavit, yes.
Milord, I have disclosed. My lord, the FIR, my lord, if your lordship kindly sees, I know this is not the subject matter, but I'm only this much, only for my lord, kindly. Please come, my lord, to page 19 of my supplementary affidavit, my lord.
Yes.
If my lord sees, my lord, this is the arrest of Mr. Garg which has taken place is pursuant to this FIR, 22nd of July 2026. My lord sees date and time of FIR, right hand side, 22nd of July 2026. Mr. Garg was arrested last Saturday after the matter appeared before your lordship on Friday and PF sought instructions. But as your lordship has rightly said, we'll take steps. But there's only one thing, my lord, which I want to show your lordship. In connection with this FIR, the amount that has been quantified, my lord, by the PF authorities, we have already made payment of that amount. Mr. Agarwal will kindly hand over a certified copy to your lordship. We have made payment of the entire
Now, Mr.
amount
Banerjee, if you
covered.
want, I can, Mr. Banerjee, if you want quashing of this FIR, I give you liberty to take steps. For quashing of that FIR, you say that there is no ground, the amount has been already paid. You take steps, I can give you liberty to
Yes,
take steps
please give
against
me
this
that liberty,
FIR.
but side by side, my lord,
Yes.
today the matter is coming up on bail. Today matter is coming up on bail. My lord, kindly,
Yes.
my lord, record, my lord, if the PF authority says that this FIR, my lord, has been satisfied. Kindly see, my lord, from the
No, Mr.
certified
Banerjee, today you have moved the bail petition.
Today we'll be moving bail again. The matter is, I think, coming up, my lord, today.
On 31st.
Oh, 31st is
31st.
coming up.
So then Mr. Banerjee, it's better not to make any observations on this, in this writ petition. It's better because otherwise it might be, yes, what was.
Worship, only that is why my lord has been
My lord, only one
say
prayer,
that
my lord,
they
please
are, what is
protect
the
us, Lord,
actual,
protect
they are
us
want
for
to
one day.
pay.
There are
Lordship
so
kindly come
many
to the page
FIRs
number
coming up,
86.
please
That is
protect us. My lord, if they,
Yes, yes.
paper us with
Sorry,
FIRs, we
86.
won't go anywhere.
This is a recommendation of the Honorable Justice retired Sapre. And
Page.
86, 86.
Yes.
And in this case, in this settlement order dated 22nd July 2022, Lordship, in Justice Sapre's committee, kindly come to the 87, page number 87.
Yes.
There is a list who are the defaulters. And the first of one number Longview TSC.
Yes.
At that occasion, this is defaulter 6,60,079,615.
Yes.
That occasion, it is on 22nd July 2022. That is the 92, page number 92. It has been found.
Yes.
Lordship. And they have been granted this equal-instrument at the page number 88. Come to page number 88.
Yes.
Paragraph
72. Yes.
88.
Page 88, paragraph 9.4.
9.4, 2
That
crores.
Mr. Banerjee has placed.
Lordship.
Yes.
Now, Lordship, in connection with this recommendation, they had didn't take any steps. Now, Lordship, come to the page number 93. 93. This is the letter dated 5th July, 5th May 2023 on part of the department. It is were informed that take the initiative to comply the order of the retired Justice Sapre. And in connection with that letter, Lordship, kindly come to the page number, on
95.
para number 9 of the application. Para
Yes.
number 9 of the application. Para number 9 of the application.
Yes.
Sorry, Lordship, 93.
Yes, I've
Lordship-
seen. Now he's coming up with different stories. Allow him to come with the calculation.
No, Lordship, there is a now.
Sir, you want
page number
some,
10.
you want
My
the
lord,
money
on
to be
27th of July
Yes.
also, we
Lordship,
have made payment.
now it is
after
for 10
attaching, how much money you have realized?
25
After
lakhs
attaching,
we
how
have
much
paid.
money you have realized?
Nothing,
Lord,
no, because of
25
So
lakhs we
please
have
wait for
paid.
a day. Let them give the
10 crores,
calculation.
it is already 10 crores now.
From
Lordship, now
August
10
25,
crores.
Lord, only one
Yes.
And
case.
Lordship, and
Mr. Banerjee, please calculate that and come with a acceptable suggestion to the authorities.
Absolutely.
I can
Don't
answer
come
that.
with an unreasonable
I can
suggestion.
answer. My lord, I am coming tomorrow, only one prayer,
Kindly
Lord, only one
send to
humble
the
prayer.
department and also me.
Only
They
one
will be
humble
sending
prayer.
to you.
Okay,
You
okay.
send it to the department.
Yes, my lord, only one humble prayer, my lord. Let there be no further vacancies till tomorrow.
I'll come back with instructions, Lordship.
Tomorrow,
He has to take
I have
instructions.
to take
You give it to him, I'm keeping it tomorrow. Give it to
Yes,
him by
yes.
2 p.m. because he has
Yes.
to also take instructions from
Yes,
the
yes,
authorities.
yes.
He's a creature of instructions.
Yes, my lord, only
Awesome.
one prayer, only one prayer. Let there be no further
Yes.
vacanting till tomorrow, please, please. I beg your
Yeah.
lordship. No
After
further
some
coercive
argument,
steps till tomorrow, my lord, and give us liberty to move regular bail, my
Heard
lord,
Mr.
before the
Banerjee.
Kurseong court today.
Heard Mr. Banerjee, learned advocate for the petitioner. Full stop. The petitioner is directed to produce a calculation sheet showing the amount due as on the date of passing of the order by the committee till date, and supply a copy of the same to the learned advocate for the Provident Fund authorities. Full stop. List this matter tomorrow under the same heading. Full
Please
stop.
protect us.
My presence.
Please protect us, my lord. Please protect
Yes,
us
your
till tomorrow.
presence will be recorded. The respondent authorities are directed not to take any coercive steps, further coercive steps,
Till day after, my lord.
till
Day after,
No.
till day after tomorrow.
till July 31, 2026. List this matter on 30th of July.
My lord, only one prayer, my lord, liberty to move regular bail, my lord, in connection with the FIR. Liberty to move regular bail today, my
No,
lord.
if you want, I can give you liberty. Mr. Banerjee, do you want liberty?
Liberty to move for regular bail before, my lord, the today, my lord, in courtesy of.
All right.
All right.
Mr. Banerjee, learned advocate, appearing in course of hearing of this writ petition, Mr. Banerjee, learned senior advocate for the petitioner, draws the attention of the court to the first information reports annexed to the supplementary affidavit.
My lord, kindly, my
Full
lord,
stop.
mention the FIR number, my lord, so that, my lord, I can.
Being
FIR
FIR number, FIR number likhta hua na, which is annexed, a copy of which has been annexed at page 19 of the supplementary list. So it will be open to the petitioner to take steps in accordance with law.
My lord,
for the,
move regular bail, my lord, we are
for-
contending that we have made payment of that amount. We have made payment.
No,
Only
Mr.
that
Banerjee,
shall
I-
be recorded, my lord.
make that submission there. I gave you liberty to take appropriate steps
I'm
before
okay.
the appropriate forum.
I'm obliged. Deeply
Yes, call that supplementary list matter.
Supplementary list, item number 1.
Yes, sir. When can you file it?
Yes, today itself. also.
Today itself.
Today or within 1 week,
So I'm,
because we are ready.
Yes, I'm extending it
And
till
as per
till
the
31st. I'm extending it till
Lordship,
31st.
as per the
So rejoin that to be filed by
4 weeks.
4 weeks. Why?
2 weeks, your lord.
So that I can place it before the next circuit bench. Mr. Agarwal, learned advocate, appearing for the respondent, prays for extension of time to file the. Was it a report or what is the affidavit?
Not a counter affidavit, Lordship. There is only the two issues.
All right,
No,
an
no,
affidavit.
Only the limited issues that we are
No, no.
addressing. Only
What was the
affidavit.
direction to file report in the
Affidavit.
form of an affidavit or the affidavit in opposition? Please show me that order by which time was fixed.
Yes, the last order, Lordship. Only to file the affidavit on the issue.
Filing an affidavit, all right.
Yes, not the affidavit in opposition.
Well, to file the affidavit
To clear the
in
stand,
terms of
Lordship.
the order dated, in terms, as directed by the order dated 9th of July 2026, on or before July 31, 2026, upon serving an advance copy of the same to the learned advocate on record of the petitioner, Dr. Muralidhar, learned senior advocate, prays for extension of time to file the reply to such affidavit.
Not extension, it's time. No?
Yes, prays for 2 weeks' time
Very well.
to file reply to the said affidavit. To stop, the petitioner will be at liberty to file the reply affidavit. Can you do it by 10th?
So 14th, my lord.
14th, then it will take to the last week of the next circuit, because the next circuit will be starting from 10th.
Oh, I see.
So
Very
if
well,
you can do it within 10 or 11,
11.
so that you get.
Very
Let such reply affidavit be filed on or before August 11,
Very well.
2026, upon serving an advance copy of the same to the learned advocate on record of the respondent. Full stop. The what was the interim order?
Well, it's that
There
they
is
will
no
not
interim
take
order.
any coercive steps in the meanwhile.
By which order?
No,
No,
there is
no
no
order.
interim order
No
yet.
order.
But my lords, they were taking time, which is why
So,
lordships did
but
not
we
pass
have-
an order.
Lordship, we have not issued any recovery notice.
All right, since the respondents have prayed for extension of time to file their affidavit, no coercive steps shall be taken against the petitioner till August 14, 2026.
Well,
That is why you will be getting a chance before the next cycle.
very well, very well. Obliged.
Acha, Khordin, list this matter before the next available circuit bench, subject to the convenience of the honorable judge.
Obliged.
Thank you.
Obliged.
Yes.
Yes. I'm happy.
Yes, yes.
My lord, the issue is that, my lord, that in course of taking possession of the secured asset of the performer respondent, my daughter, under section 4 of section 13, regulation 14, they have dispossessed me from the property, which is not the secured asset.
Yes, sir. What do you say? Is it a fact?
Lordship, the reach itself is not maintainable.
No. If it is not maintainable, I am aware of that. But can you take possession of a asset which is not a secured asset? That is Mr. Rai's submission.
Lordship, then I have to take instruction.
Please take instructions on that. That you
From
cannot do.
From the
Then writ petition will be maintainable.
on the record, I'll show you. My lord.
Lordship,
On the record, I'll show.
Mr. Rai, please show because he has to take instructions. Please show.
a single line order may be in that regard. A single line order may be in that regard.
No.
Please hear his submissions. We will be showing that.
His argument is altogether in writ petition. He is very detailed in drafting.
And he comes on the
But but he is not that strict so far as his juniors are concerned.
No. He is
not
always very
saying
kind
strong
to us.
words to his juniors.
No. He is very kind to us. We agree.
Then that's the difficulty with him.
My lord. Can you come to page 19?
Yes.
He filled it.
19.
That is, my name is Birendra Chandra Rava. That was given at page 19. Has got it, my lord.
Yes.
I purchased it. And this is my lord, page 20. In the middle, the schedule of the property.
Page 20 RS 3346.
3346. 3346 শতকে 3565 এর 1.415 শতক and 3347 শতকে দাগের this is my lord 3.120. I just here I have given and the petition I have given. The petition is the owner of the 1.415 decimal in
In the
RS.
petition you have stated.
This is in paragraph 2 and 2B. I've given everything. Can you see?
Yes. 3346 Ela plot number.
Yeah.
This is the yes. So
Yes.
this is your ownership.
So this 2 and 2B, total land is mine, my lord.
Two separate land.
Yes. Total land is
No, two,
mine, my
not
lord.
three separate. No, sorry.
No, the two plots, one in a one deed,
Yes.
other plots, my lord, in the second deed. So,
Yes.
so my lord, my total land is 5.135 decimal. Can you 5.135 decimal in 3 LR plots, 3464, 3465, 3469.
Yes.
This is
Yes.
administration. Now, my lord, I gifted the property to my daughter. This is I given in my lord.
27th May.
Just a minute.
Oh, 24th of November. Sorry.
Kindly come to my lord 3A.
Yes.
3A. The petitioner through executive register did not give because the following serial line in favor of his daughter. This is I have given 3.756, 1.1144, 0.66. So
Yes.
total I've gifted to my daughter is my lord 2.5 decimal and 2.5 decimal and our is total 3.061.
Yes.
So in my hand remains 2.2 my lord, no, 2.074. This is so 2.074 in my hand, I gifted her. Now, my lord, my lord, she has taken the loan from the bank. If you also kindly come to page, that is at page 70.
Yes. 70.
Zero. This is a sanction letter. My daughter took the loan,
Yes.
20 lakhs loan. Now can you see notice under section 13(2), that is at page 77. This is a notice under section 13(2). I can give the schedule of the property at page 78. What I have said, that is 2.5 decimal and 0.561. You got it, madam?
2.5 decimals.
2.5 decimal in one plot two plots. Another is 0.561. Next,
Oh, 0.56.
that is what total is 3.061.
Yes.
But this is a road. The next plot is a road. 3.0061. This is a secured assets. Which is I gifted her. That is the schedule is the secured assets schedule, my lord. 13 to say. There's my lord, kindly come to.
So there is no dispute with regard to this schedule.
Yes, there's no dispute.
Yes.
So my lord, can you see next one? I'm position notice at page 82. Same schedule of.
Yes. Now where the dispute starts?
No. Can you see page 82 is there? Yes. So my lord, then my lord, I just showed that I'm coming. Just can you come to page 86?
Yes.
It is the 14 application, relevant page is, my lord, 91. Same schedule. Page 91, the same schedule.
Yes.
Now, my lord, order was passed at page 105. Page 106 is the relevant page to take the position of secret asset. 106, my order part. No, my lord,
105.
it starts from 106, the order is passed to take the secured assets and the
Yes.
portion. Now, this is the situation. But now both the properties are identifiable and separable. I said, giving one, the photograph I show it. And you also can come to page 67, photograph. Sorry, my lord. But this is the hard part is the back side. 67, the front side is mine. Back side, my daughter's. Got it, man? Page 67. Front, past the
Colored one is yours.
Yes.
White is your daughter's.
Back side is my daughter's.
Yes. White.
Yes.
White painting is your daughter.
Now, my lord, can you come to page 68?
Mr. Rai, you have colored your property and you have not colored your daughter's property.
This is my dear. This is colored. I be a colored, but my wife, daughter is not colored. I don't know. So
As a father, you ought to have also colored
yes.
your daughter's property.
So you should do it.
Yes.
Identifiable and separable. Now, my lord, on 16, the officers has come. Kindly see, my I lost the FIR. And people have given the notice at page 108. They given notice in my house. And they can take the securities of my daughter. I am not concerned. Can you see my page
Now the
109?
possession has been taken.
What happened? They have taken the position of my daughter. And they have also taken the position, this position is me from my own portion.
No. So the possession's taken.
Yes.
Of both the
Both
property.
yes, this position is me.
So now you are concerned only with regard to your
My
property.
this is 2.074.
Yes.
These are the secured asset. How? But my only point is that they can take the
Now what is your pair here?
return.
Return of that.
This my lord, I show you this judgment, but I'm calling. I can also I'm always trying to.
Can I have a copy,
This
sir?
initial. Okay, we will not.
Yes.
Can our division bench judgment, man?
Yes. Sir, I have given me 2 copies.
Yes, sorry.
Yes.
Can I have 10B? 10, sir.
Yes.
In view of the above fact, we find that there was no valid mortgage in favor of the IDI Bank Finance Limited in respect of flat in question, other the instance of his petitioner or his predecessor who was undisputed the owner of the property. The IDBI Home Finance Limited, as appears from records, on the basis of an agreement of 2 persons, exercise the alleged right under section 30 of the, although by such agreement no such right accrued in his favor at any time of entering into such agreement or even subsequent, those 2 persons never acquired any title said flat from the lawful owner. We have the view that in the facts of the present case, where the citizen of India has been harassed in this way and was dispossessed from his lawful property as an instance of financial institution who had acquired no interest over the property in question, so as to enable it to exercise power conferred under section 13(4) of the Act. Such a citizen is not required to go to the alternative remedy provided
Yes,
under.
so according to you, In respect of your property,
Yes. they-
13(4) could not have been invoked.
So section 17.
So 17 also
No, no.
cannot be the
This is
remedy.
central law.
So,
So I'm covered by the article 308.
that is,
So
yes, sir, what do you
I
say?
can see here, operating parties to return the property.
Operating parties?
Is my lord, to return the,
Yes, yes.
and damage also given.
Damage also.
Worship,
what-
allow me to take instruction and file a
Please
affidavit.
take- What affidavit, sir? If, according to you, it's clearly, look, there are two things. He was the owner of the entire property. Now, he has gifted a part. Now, the only question, I'm not saying much because,
I understand.
so gifted portion.
I understand.
So you have to see what was the gifted, whether it is separable or not.
Very
That's
well.
the thing which you have to consider.
Very good.
If it is clearly identifiable, these two plots,
Yes.
these two properties, and this is not only a vacant land, it's
Yes.
a, it's a
Adjacent
constructed
land.
house.
Yes.
So if the constructed house, this can be easily identifiable with regard to these two portions.
Yes.
So you cannot claim his portion because.
No, obviously I cannot.
So you cannot claim his portion.
Yes.
So he is not aggrieved by the portion which you have taken over from his daughter.
Yes.
He is not canvassing, he cannot also canvass.
Very well.
And he cannot also canvass in this writ
No,
petition.
I can do it. I know it.
So he is not canvassing that. So the only thing is that, whether, please take instructions, if that is so, you cannot hold that.
No, no,
Because
obviously.
ultimately, if it is found, then damages, the period which you are
Yes, yes,
illegally
yes.
withholding, that will multiply.
Yes, yes.
That's for that,
Worship, the problem is, I have to send all my queries to Calcutta office. Head office
This
is
is
in
last,
Kolkata.
last 16/6, my lord. Last circuit, he was not here, his mother was ill.
Yes,
I am
yes.
dispossessed, and see, my own person, I was dispossessed. And
No,
my
the
FIR
only
at
thing is that
109.
I need some time, extra time to take
Sir, I
instruction.
only
I
one
cannot
thing,
say anything of my own.
I appreciate your anxiety also.
But on 16/6, when I see my FIR, they are disposed all, they have thrown everything. But these are like a gundas, my lord.
Lordship, allow me to reply on this because.
There's a
these are
lawyer
the
is
facts
there,
which
one
I don't
competent lawyer.
know.
Come back tomorrow.
Yes, Lordship cannot, trust
Why
me.
does it go in the matha manga? It is in matha manga. You have
Lordship,
taken the
I have
15 days
to
earlier.
put my questions to Calcutta office. Calcutta office sent to the head office in Guwahati. They will, then only I'll get
But
the,
yes, now the-
No, no,
again,
uh,
it will come back
This
to me
was
on the.
mortgage before the branch.
Yes, Kujibihar branch.
Then
Lordship, I don't think
what
it
they
will
will
be,
do?
Yes.
bank
But-
people will not be able to, from their legal
No,
department, they
then
will
they have
again
taken,
take
they've
instruction.
taken it. Then
3-4 days at least, Lordship, otherwise how do I?
you have dispossessed me.
They have to give
Who's
some
the-
report,
who's the very-
otherwise the burden
like a
will come
gunda.
on me.
And there was a FIR. And you have
I-
not on.
I
They thrown all
understand the
properties.
anxiety,
They
but
thrown all properties.
I cannot take the burden on my head, Lordship.
Last vacation, my junior, my London friend was. in
I was
Calcutta,
not
so
there.
I can't take.
Lordship, I was not there.
No,
I
no,
agree to that.
accept you.
Huh.
But can you see my clients? He's out
Sir,
of.
please try. I'm keeping it tomorrow. Please make an attempt
Okay,
because please look the anxiety of a person.
I understand.
So if he has not given that property, if he had not mortgaged
I'll
that,
try.
he's out of the
I
possession.
understand,
Please
I understand.
consider that. Please, if you can, please consider this. If it is a clearly identifiable property, you cannot take over.
I'll
And
send
Mr.
to
Rai,
come.
only one thing.
Yes.
Is these properties mutated in the municipality?
Yes. The different name.
No, please show me.
No.
Only one thing,
I
Mr.
should
Rai.
take the instruction because.
Mutation
Yes.
Mutation because.
Yes,
Mr.
I
Rai-
understand.
Yes.
It's a
So-
common road, my lord. It's a
Yes,
common
no,
road,
no, common road might,
but I understood, my lord.
with regard to the deed numbers, plot numbers,
The
that
land
reference will be there in the municipality.
Yes.
land report is there.
Yes, land record is there. That's mutation with the revenue authority.
Yes,
That's
yes.
one part.
I
Another
I
is the
understood,
municipal
but demand
authority.
is
Yes.
easily demarkable. But
Because, yeah, easily identified.
but problem is that when the lawyers commission is there, you should measure it. What is their property? I don't know why.
Mr. Rai, you also did not raise that point there at that point of.
I was not there. My wife,
Your daughter was there.
no,
but she
daughter,
was-
my
Mr.
problem
Rai,
is,
don't say this that you did not have.
is
the
my
knowledge.
daughter. Problem is I have no relation with my daughter. My brother, this was a brother and sister. The old person became a very, I served upon her, he did not receive it. He took the loan, this is a brother and, so, you know,
Now it's between the brother and sister.
but now, father is the owner.
Yes.
This
Father
person,
gifted a portion to the daughter.
and son expected he will get the remaining part.
Oh, now who is the petitioner? Petitioner is the father.
He's a hapless mother. Page 109, if I lost the paper, immediately can you see, I've said everything.
Advocate commissioner, you have also implemented.
Yes, he was.
Where is he?
He did not receive, I did not get him.
No.
In the order he said he's practicing.
He's a practicing advocate.
In
where?
the order he said he's practicing Kujbihar court, but I served in the Kujbihar Bar Association, that did not serve. It's finished, okay? His enrollment number, I tried to,
What
that
you will
Noyan
do with
Goswami,
What you will do with the enrollment number?
no, I can't get it.
If you can contact, if you can inform
I
him
tried
that
to,
tomorrow-
because he said here order is a Kujbihar Bar, I sent the copy to Kujbihar Bar Association. They said, no, he's not identifiable here.
Not identifiable.
Somebody told he's practicing.
Maybe doing only bank work, so he's not regular in court even.
He has said that he's a Bar
That,
Association
that may be the
at court
possibility.
pays 106.
Advocate of the bank, then you must be knowing.
No. The advocate, paneled advocate is working for this bank.
He has been trapped.
These advocates are, no, why I'm trapped?
You should know.
No, how do I
Now
know?
somebody does that.
These are only the panel advocates.
I just tried. Tomorrow.
Hard, Mr. Rai Lanet, senior advocate, appearing for the petitioner. To stop on the prayer of Mr. Sarkar Lanet, advocate, appearing for the bank. List this matter tomorrow to enable him to revert back with necessary instructions. Please take these instructions. If it
I'll try my level best.
identifiable, because a person is out of
I
his
understand,
possession of
I
his own
understand.
property.
I'll definitely try. I'll try. Grateful.
Yes. Call the next matter. আচ্ছা সেম হেডিং করবেন না সেম হেডিং করবেন না মোশন ফোশন
Item number 20.
My lord, I appear for the state. Now, my lord, on my request, the lordship was pleased to keep it today. I had handed over an order by the concerned authority regarding, my lord, license of a FL shop. May I hand over one copy to your lordship? I'll give one. I've given Mr. Ghosh the copy also.
So now he has to challenge that.
Yes. Hello,
Mr. Ghosh, you have got the copy.
Yes, thank you.
What was your grievance that it was not being disposed of? What was your
This
grievance?
was not being disposed of. Despite making a representation, they were not convening a hearing.
The primary grievance of the petitioner is that the district magistrate Jalpaiguri, being the second respondent, did not dispose of, was not disposing of the representation of the petitioner dated 12th of March 2026. Full stop. Mr. Bhattacharjee Lanet, additional government pleader, produces a copy of the order dated
2nd of July.
2nd of July 2026, passed by the additional district magistrate within bracket G and collector of excise, Jalpaiguri, rejecting the prayer of the petitioner, full stop. By the said order, liberty has also been granted to the petitioner to prefer an appeal before the Excise Commissioner West Bengal in terms of Rule 3 and 4 of the notification number 595 SR dated 30th of March 1915.
Yes.
Is it correct?
My lord.
কিছু নোটিফিকেশন লিখবার দরকার নেই বিফোর দি এক্সাইজ কমিশনার বলে ফুল স্টপ লিখে
Firstly, that only. Mr. Ghosh will know, my lord. Mr. Ghosh has done a lot of cases for excise department.
Here maybe, all right, let us not go into that. Full stop.
In terms of the relevant
Since-
notification.
In terms of the relevant notification, since the representation has now been disposed of by an order dated 2nd of July 2026, and an appeal lies therefrom, this court is not inclined to entertain this writ petition.
No, my lord, the prayer was only that dispose of my representation. So the representation has become.
তাহলে হ্যাঁ,
has
তাহলে একটা কাজ করুন, কি বলে না, since the
infraction has become infraction.
since the
Infractuous.
has already has not been has now been disposed of,
No, infractuous shall
हाँ,
be useful.
nothing survives
Yes.
to be decided
Grateful, my lord.
in this writ petition. Full stop. Accordingly, the writ petition stands disposed of. Full stop. Since the order dated 2nd of July 2026 is an appellable order, petitioner is left free to work out his remedies in accordance with law.
Grateful.
Now, only Mr. Bhattacharjee, only one thing I was, please see the last order whether your name has been correctly recorded, spelled,
Okay, my lord. I'll see.
because I had some, please check up, because in many orders I find this, but whether it has been correctly spelled or not. Your surname,
Yes, yes, my lord, Bhattacharjee.
J-E-E, you write J-E.
Yes, sir. J-I-T and J-E.
This surname is my lord very
My lord, how-
differently spelled for
this,
different.
this surname is being spelled in different ways by
Yes,
different, that is why, because since I am having the same surname, I was
Yes.
confused, bit confused.
One thing, I was, my lord, in Secunderabad, my father had a transferable job. So I remember one of my teacher asking that why is G written after your surname? Oh, my lord, innocently or something, I said that people will always respect me and say G, my lord. Good.
Yes.
Item number 22.
My lordship, I prefer short Passover. The
Passover,
senior counsel is on the way.
yes,
My lord, I am appearing
yes,
for the petitioner.
Passover next.
23, Milords, I am for the petitioner. Milords, this is the matter where my vehicle has been blacklisted in the centralized portal of WBMTDCL, that minor minerals matter.
Mine minerals, my lord.
Yes, for what, on what ground?
On what ground? They have not provided me any ground, any sort of order, intimation, how they
Yes,
have
Mr.
seized.
Bhattacharjee.
One of the series of matters, my lord.
Yes, what is the ground on which that it has been blocked?
Yes, in ground, my lord,
The,
that
it's the
non-payment.
each
Non-payment-
generation of each challenge has been blocked.
Yes, my
Non-payment
lord.
of
Yes, my
royalty,
lord.
non-payment of royalty, my lord, and accordingly, he was asked to meet the district land and land reforms officer. But even then, if he does not there, under the rules of 2002, my lord, the remedy is there. I'll tell your lordship the remedy, my lord. He has a statutory remedy. I'll show it to you.
No, please, you have communicate the decision, he
Yes,
will
my lord.
take that. Where is the decision? Please show me that you
There
have
is no
that.
decision as such,
Milords,
but
the
it
issue of
is-
maintainability which has been taken, that has been dealt by Justice Rai.
Not a issue of maintainability. Now, according to you, nothing was
Yes, yes,
communicated.
It is not.
They are communicating, you take steps.
It is, my lord, uploaded in the website.
Please,
And from there, my lord, the website, they have come to know. There is no personal, my lord, communication that.
all right, so what is the reason?
But the reason is that non-payment of royalty.
Whether my vehicle was
No,
even
please,
loaded with minor minerals.
Communicate that decision to them.
Yes, my lord.
Yes, then my lord, in that event, because lordship can see that there is an instruction to me.
Yes.
Opportunity
So
of
I
being
give
heard.
you, I direct you to communicate the reason decision within a time,
Yes.
and they will be
I
entitled to
will
take steps.
My lord,
Yes,
in the meantime, opportunity of being heard, I will file my reply to their.
Take steps,
Ah.
do whatever you want. I will direct them to communicate there. Mr. Bhattacharjee, which paragraph?
My lord, second paragraph.
Second paragraph and last.
Second and last. Second paragraph, I'm placing it, my lord.
And last.
It is submitted that the West Bengal Mineral Development and Trading Corporation Limited, being the nodal agency of the government of West Bengal in matters relating to the management and monitoring of minerals, has developed and maintains an online portal and mobile application through which all valid transit permit challans for transportation of minor minerals are electronically generated and recorded. Before taking an enforcement action, The checking officer verified the particulars of the said vehicle through the WBMTDCL mobile application and found that no valid transit permit or challan had been generated or approved in respect of the said vehicle for transportation of the minor minerals in question. Consequently, the checking officer found that the transportation of the minor minerals.
So now he has to approach the DLLRO
Yes,
for
my lord.
getting the vehicle unblocked.
Unblocked.
Lord, my contention is whether my vehicle was even loaded with minor minerals at the date.
Sir, please approach the district land and land reforms or raise all contentions there.
Yes, Lord. I will find my reply.
Uh, 4/2/2020. Where is that memo, Mr. Bhattacharya? 4/2/2020. So this is the.
That copy enclosed memo, my lord, is asking for.
Mr. Bhattacharya, can you do one thing? Can you give them the copy of this report so that they can, on the basis of this, they will
Yes, my
apply,
lord.
approach the district land and land reforms
Yes,
officer?
This is not a report, this is instruction.
This is not a report. All right, I am recording your
My lord,
submission.
I think memo is on the, I'm handing over.
Memo,
Last page, my lord.
yes, memo is the fine. All right, I am recording. Please hear this. So all the matters are same.
Same.
So a common order can be passed in
Yes,
all.
my lord.
Yes.
My lord,
One of the matter is pertaining to Alipurduar district. That
Deal
is,
or Alipurduar will be the.
Alipurduar. Which is that matter?
item number.
একসঙ্গে করলে কি অসুবিধা হবে?
my lord.
কিন্তু
তোমার গাড়ি details আলাদা।
Details আলাদা, গাড়ি নাম্বার, গ্রাউন্ড সবার
My lord,
হয়তো uploading এর problem হবে, তখন তো একটাতে দেখতে পারবে।
item number 32 মিলার আলিপুরদুয়ার স্বপন রায়।
অসুবিধা।
না, বাইকে নিয়ে আসলে কোনো ফাইল নেই। ঠেলাই করে নিয়ে আসলে কোনো ফাইল নেই। গ্রামপাড়ে কোনো ফাইল নেই।
Which is from the different district?
32, item 32.
my lord, may I make one number, sir? Can my learned friend for the petitioner supply your lordship's officer with the different, because vehicle numbers are different. So the,
Vehicle numbers have to be put in.
it will help him or not, I don't know.
All right, then
Then my lord,
separate orders I think will
he
be.
can do one thing, my
I will
lord.
do.
The item number,
And
the
alongside the vehicle number.
he can provide it to your lordship's officer and separate.
I will do it.
All right. You are the owner of the vehicle.
Yes, my lord.
Separately করে দিন, petitioner claims to be the registered owner of a heavy goods vehicle bearing registration number WB 73G2059. Full stop. The petitioner claims that he is earning his livelihood through transportation of riverbed materials, stone chips, gravel, and other mining materials. Full stop. The grievance of the petitioner is that on a particular day, when the vehicle of the petitioner was sent for obtaining e-challan, the driver of the vehicle was informed that the royalty could not be generated in respect of the said vehicle. Full stop. The petitioner states that in the computer screen, a message is being displayed advising stating that e-challan cannot be generated against the said vehicle and a case has been initiated and the owner of the vehicle has been advised to contact the office of the district land and land reforms officer, concerned district land and land reforms officer for getting the vehicle unblocked. The petitioner has approached this court alleging that the generation of e-challans have been blocked without affording any opportunity of hearing to the petitioner. Mr. Bhattacharya, learned.
I am there in only one case. So instead of recording my name,
The learned advocate appearing for the state files a copy of the instruction addressed by the concerned block land and land reforms officer, which is taken on record. Can it be taken on record?
as your lordship said, it can be.
Acha, darkar nahi.
My lord,
Uh,
kindly keep it with the record because
It's an instruction.
Sorry, it's an instruction to the learned advocate.
Oh.
The learned advocate appearing for the state on instruction submit. So you submit with a category on written instructions given by the concerned block land and land reforms officer to him, submits that
Paragraph 2, 3. And so.
that the checking officer found that the transportation of the minor mineral by the vehicle in question was being carried out in violation of the provisions of the West Bengal Minor Minerals Concession Rules, 2016, particularly Rule 3 within bracket 1 within bracket small b. And for such reason, the vehicle was immediately blocked through the WBMDTCL, all capitals, MDTCL mobile application after uploading the photographs of the vehicle at the place of interception. The learned advocate for the state further submits that a message was being displayed in the website, was being displayed through WBMDTCL portal to the registered mobile number of the vehicle owner, advising the vehicle owner to contact the office of the district land and land reforms officer Jalpaiguri for getting the vehicle unblocked. Full stop. Paragraph. The learned advocate appearing for the petitioner would submit that the petitioner, that neither the petitioner nor the driver of the said vehicle had violated any provisions of the 2016 concession rules. Full stop. Since
or sand mining rules also, Miller. Sand mining
or
rules,
any
2021.
other relevant statutory rules. Full stop. Paragraph. Thus, no, that's not. The dispute involved in the instant writ petition involves a factual adjudication. Full stop. For such reason, this court feels that liberty should be granted to the petitioner to approach the concerned district land and land reforms officer. Full stop. Paragraph WB, the writ petition. Number lekha darkar nahi. Accordingly, the writ petition stands disposed of by by giving liberty to the petitioner to approach the concerned district land and land reforms officer, being the
District authority under
being the respondent number is the district land and land reforms
Yes,
officer.
yes, yes.
Being the respondent number in all the matters, he is the respondent number 5.
Yes, five.
Being the 5th respondent. Full stop. If such authority is approached, upon an approach being made by the petitioner, the said respondent authority shall consider the case made, the case of the petitioner and dispose of the same in accordance with law as expeditiously as possible, but positively within a period of 2 weeks, because the business has been stopped.
Millard, limited time protection, Millard. Otherwise.
No. Within a period of 2 weeks. That is why I have requested him to dispose it of within 2 weeks. 2 weeks from such an approach being made. So it is, however, made clear that all points are left open to be raised before such authority, and the authority shall consider and dispose of all issues raised before it in accordance with law.
My lord, kindly observe that the authority will give me the grounds of this detention, because I am disputing that my vehicle were not at all loaded with mineral minerals. I have seen the photograph in the report.
I've said, I've recorded in the order from their instruction that is the allegation. You satisfy that authority. Because I've also recorded, they have uploaded the photograph also.
Photograph of only the number plate.
So you disprove that.
One thing, it will be Lordship's pleasure to record, my lord, after DL and LRO, they being the district authority under the West Bengal Mineral Minerals Concession Rules 2016.
District Land and Land Reforms Officer, being the district authority under the
West Bengal Minor Minerals Concession Rules 2016.
Obliged.
Yes, now please give your vehicle numbers in all matters. And to approach the district land and land being the respondent number 5 being the respondent number 5. Purport to take
Passover item may be taken up, my lord.
Yes. Purport 23 কোথায় গেল?
Passover matter.
23 for please in a piece of paper, please give the vehicle numbers as well as item number. I will do. Yes, item number 24
State is there.
disposed of
25,
State is there.
25
26,
disposed of
27, 28,
State is here, my lord.
29,
State will
30, 31, 32, 33, 34, 35, 36,
Yes, ma'am.
37.
Up to 37, my lord.
up to 37. Which one is Alipurduar? 32 টা আলিপুরদুয়ার দেখেন, আমরা তো ডিস্ট্রিক্ট কিছু বলিনি।
No.
Concerned, I've said concerned district.
Yes, my lord. My lord,
Yes.
may I take back the instruction?
Yes, please take back the instruction. Yes, call the next matter.
Passover matter, item number 22.
My lord, I'm appearing for the petition.
My lordship,
Yes, yes.
My lordship, respondent counsel is in court number 1, my lordship. One is Lex.
Who is in court number 1?
Mr. Banik, Ratan Banik.
How many times you are here?
Well, 38 is also there. He just
All right, pass over next.
38 also same, my lordship.
32 also same.
38.
38 also same. All right, pass over next.
39,
39, yes. 39, who is appearing?
My lords, I'm praying for a short Passover, my lords.
Pass over next. 40. 40.
This is quantum application. Order has been complied.
Complied with. The learned advocate appearing for the petitioner submits that the directions contained in the order dated blank has already been complied with. First up, In view thereof, the contempt application stands disposed of. Next,
41, 42.
42 is appearing.
Passover matters will be taken up at 2 p.m. Passover matters will be taken up after lunch. 39 Millard was the division. That
39.
municipality matter, Millard has considered it substantially only.
All right, I'm taking up after 2 p.m. There is one fixed matter. After that, I will be taking.
Lordship 42, 49 is sent.
42 also complied with. 42 complied with. Same order. Please order a date. 49 also complied with.
Yes, Lordship. 42, 43, 44.
42
Till 49 is
till 49 complied with.
Yes, Lordship.
No, 49 is 48, say, because 49 is the read petition number.
Yes, Lordship.
42, 44, 46, 48 complied with. Yes, call 50.
50, my lord.
I don't have 50.
Complied.
No, my lord.
Not complied.
Complied.
You are the odd man out. All orders complied with.
What's happened, my lord? I sent the letter, my lord.
Yes, what was the direction upon whom?
The district inspector of school, Alipurduar, my lord.
Upon?
District inspector of school, primary education,
District
Alipurduar.
inspector. So, yes, Mr. Bhattacharya. Why are you not complying with?
Sorry, my lord, I will comply. If a copy is given, my lord, kindly.
Please give him a copy.
Contempt the other.
Please give a copy. Contempt application served.
Yes, my lord, sir.
Affidavit service filed in court today is taken on record.
Forwarding letter is here, my lord, but affidavit service,
Please file the affidavit of service. This is the contempt application.
affidavit service, my lord, the misplaced from my custody, my lord, today.
You have misplaced the postal slip.
Yes.
All right, then you serve a copy upon Mr. Bhattacharya. Mr. Bhattacharya, can you take instructions? Then I can record. I'm giving his copy. Then I can keep it tomorrow.
My lord, I know Friday, my lord, it will be difficult. Can it be 1 or 2?
Tomorrow is Thursday.
Can it be taken up on Friday, my lord?
Friday?
Yes, I'll get instructions. My lord.
All right. The learned advocate appearing for the petitioner submits that though the copy of the contempt application has been
Group B
served, has been sent by registered speed post, but the postal slips have somehow been misplaced from his custody. First paragraph, the learned advocate submits that the district inspector of schools primary education Alipurduar is the alleged contemner. Mr. Bhattacharya, learned additional government pleader, is requested to appear in this matter and take instructions. Let a copy of the contempt application be served upon the junior of Mr. Bhattacharya in course of this day. Let the appointment of Mr. Bhattacharya along with the junior of his choice be regularized by the concerned authority. List this matter Friday.
Friday,
List this matter on Friday.
Great.
Yes. Next.
Item number 52.
52, yes.
My lord, I have solved the respondent, my lord. It's a content application.
Yes, who is the alleged contemner?
My lord, Chairman, Darjeeling Municipality.
Chairman?
Darjeeling Municipality.
Darjeeling Municipality. Yes. Who appears for Darjeeling Municipality? Who appears for the? Yes, Mr. Bhattacharya. Who appears for Darjeeling Municipality?
Municipality Darjeeling ke Ujjwal. No.
You are appearing.
Darjeeling Municipality. Ujjwal.
You will be knowing.
Lordship, last month I appeared.
Achha,
Lordship,
she is there.
Now I need to take instruction, Lordship.
Can you appear?
Lordship, kindly keep this tomorrow, Lordship. I have to ask.
So I will direct him to serve a copy upon you. So I can record that you can appear in this matter. So you are appearing in Darjeeling Municipality matters.
Yes, earlier I appeared, Lordship.
All right. The learned advocate appearing for the petitioner submits. You are filing the affidavit service.
My lord, I have filed.
Affidavit service filed in court today is taken on record. The learned advocate appearing for the petitioner taken in service. The learned advocate appearing for the petitioner submits that the alleged contemner has been duly served. To serve in spite of service, none appears for the alleged contemner. To serve Miss Singh, learned advocate, who usually represents the Darjeeling Municipality, is present in court and is requested to appear in this matter and take instructions. So submit a copy of this contempt application be served upon her in course of this day. Friday,
Lordship.
list this matter Friday. Yes. Call the next matter.
Item number 54.
Lordship,
Yes, what is this matter?
Lordship, restoration and continuation of delay of 320 days. Actually,
320 days.
yes, Lordship, actually, entire,
You are opposing Mr. Ghosh.
No, no, I'm not opposing. I'm for the
Lordship, this
board
is
millard.
absolutely
What is the matter?
problem of the advocate. His mother was ill.
What is the
He could not
what
come.
is the main matter?
Main matter, Lordship, that is the 6 marks to be awarded as per the order of the division bench.
6 months. Yes, Mr.
6
Ghosh.
marks.
Yes, Mr. Ghosh, what do you say?
Millard, to that extent, Millard, can I come back with a short report? Let them verify it. If the claim is right, he is entitled to. I have no difficulty, but I want to come through them.
All right, so I'm allowing the restoration application.
Yes, yes, there's no objection to it.
Restoration application is can 3.
Can 3 allowed? Restoration was dismissed. There are the-
Restoration application was
that
dismissed.
was on earlier order that is restored.
Chani.
Lordship, actually I engaged just money.
What is the application for restoration? No.
Can 1, Millard.
Can
Can
1, can 1 or can 2 for delay.
Can 2, Millard.
Can 2 is for
Delay.
delay in filing the restoration
Restoration
application.
application.
So can 2 and can 1 is to be taken
Can
out now.
1 and can.
So can আছে এখানে? Only can 1 is appearing, can? Oh, 54 this is item number 54.
54 Lordship.
না, can নেই কেন?
রূপাঞ্জনা বণিক সরকার।
I have been served with. Can 1, can 2 both.
So can 1 and 2 is to be taken up.
Can Judge
এটা
Sir
দেখুন
will
দেখুন ক্যানটা কেন দেখাচ্ছে না?
Judge Sir, ফাইলে can আছে।
লিস্টে দেখাচ্ছে না তো।
Can 1, oh, can 1 and can 2 are restored. Oh, dismissal হয়ে গেছে তারপর বোধহয় restoration.
তারপরে আর ওঠেনি Lordship।
এটা তো লিস্টে না করলে অর্ডারও হবে না নাকি?
এটা আলিয়ার অকেশনে রেস্টোর হলো না, সেটা আর ওঠেনি। শুভদা
ওটাকে তোলান। তাহলে এখন করে দেওয়া যাবে তো? তাহলে অর্ডার করে দিচ্ছি। ঠিক আছে। ক্যান করিয়ে নেবেন কিন্তু করিয়ে নেবেন বলে দিই। Which is for condonation of delay. Yes, can 2 of 2024. After can 2 of 2024. This is an application praying for condonation of delay in filing the restoration application. First up, after going through the averments made in the said application and after hearing the learned advocates for the respective parties, this court is of the considered view that the petitioner was prevented by sufficient cause for not filing the restoration application within the stipulated time period. First up, accordingly, the delay in filing the restoration application is condoned. Can 2 of 2024 stands allowed. First up, can 1 of 2024. This is an application for restoration of the writ petition by recalling the order dated 18th of September 2023, passed in WPA 1314 of 2023. First up, after hearing the learned advocates for the respective parties and upon going through the averments made in the said application, this court to the mind of this court, the petitioner was prevented by sufficient cause for not appearing when the writ petition stood dismissed for default. So accordingly, the order dated 18th of September 2023 stands recalled. First up, can 1, the writ petition stands restored to its original file number. First up, can 1 of 2024 accordingly stands allowed. Full stop. Next, WPA te order korun. The petitioner, where is your prayer?
Lordship,
The petitioner has prayed for addition of
page number
marks
17.
for the wrong question / option as per the directions given by the Honorable Division Bench on 13th of April 2023 in MAT 1594 of 2018 in connection with the empanelment in connection with appointment for the post of primary school teacher in respect of TATE, all capitals, 2014. Mr. Ghosh, learned advocate, you are representing board. Mr. Ghosh, learned advocate, representing the Board of Primary Education, 6th time to revert back with necessary instructions to stop. Let a report in the form of an affidavit be filed by the Secretary, West Bengal Board of Primary Education, with regard to the allegations contained in this writ petition within
a week, Millard, at least. It has to come from
on or
Calcutta.
before August 7, 2026, to establish this matter before the next available.
Instead of allegations, if Millard kindly records entitlement of the petition.
With
So,
regard to the
if
allegation,
they say yes, he can
with
get
regard to the entitlement, with regard to the prayer, with regard to the relief claim
Yes.
in this writ petition.
Deeply
ঠিক
obliged.
আছে? তারপরে লিখুন, let such report in the form of an affidavit be filed on or before August 7, 2026, full stop. List this matter before the next available circuit bench, subject to the convenience of the Honorable Bench.
Let pull out.
Yes. Yes, next.
My lord, I am
55,
appearing
yes.
item number 55, my lord.
Kindly take up the
My
passport
lord,
matters.
55, who is appearing for 55?
I am appearing, I am appearing, my lord.
Yes,
It's a
yes,
very
what is
limited-
this?
My lord.
What is the
in
application
in
for?
My lord,
in this
only for
matter,
limited
there was a
that
direction
my
for
provisional-
filing report
Yes.
as well as the allegation made against the
Have you filed the
department.
report?
My lord, I have prepared the report by way of affidavit, but the thing is, the assistant commissioner who will put his signature, his mother is seriously ill, now he is in Calcutta. So 7 days time is required for extension.
Yes, what you say, I'm extending
My
the
lord,
time.
my limited
Report is
prayer
ready,
is
my lord.
that the laboratory report on the which they send my goods for the testing, my lords, whether.
No, you are not very audible. Sir, you are
Am
not
I
audible.
Am I audible, my lords?
Just now you are audible, yes.
Yes, my lord, my limited prayer is that my provisional release application dated 1/4/2026 is pending before them. Which was, my lords, which was the second prayer that was raised in the petition. Let it be considered by them and they should provide me.
Then Mr. Bonik, what do you say? Their application, please consider and pass an order.
My lord,
Within 2
there
weeks,
was
my
a
lord, it's
direction,
been more than 4 months.
let me submit the
Mr.
report.
Bonik, this is only a prayer for consideration. How long they will wait? Please consider.
At least 7 days, only 7 days, my lord.
Bonik, only consider this.
Without considering the report.
What
because
will
they are
happen after that report? What is
My
the
lord,
difficulty?
Magistrate has
Again-
done the
against some
evaluation,
allegation.
everything has been
They have
done.
also
No,
made
no, I
some
will
allegation.
say without
They have also made some allegation.
allegations are disputed. I will record that.
I-
I will only direct you to consider, please consider and dispose of this application.
My lord, kindly allow me, as
My
my
lord.
instruction is that to file.
Mr. Bonika, what you will do with that?
And
What you will do? You are bound to
Practically-
dispose of, when an application has been filed, you are bound to dispose that.
That's true,
So,
but how,
Ashun,
how,
Mr. Bonik, learned advocate, application ta korun, can 1 of 2026, this is an application praying for urgent hearing of the writ petition to stop considering the after hearing the submission of the learned advocates for the respective parties, can 1 of 2026 stands allowed. To stop the writ petition is taken up for immediate consideration. To stop, Mr. Bonik, learned advocate, appearing for the customs authority prays for extension of time to file a report pursuant to a direction passed by a coordinate bench on 29th of June 2026. Full stop. faced with such submission, the learned advocate appearing for the petitioner submits that that at this stage, the petitioner is restricting his claim for a direction upon the second respondent to consider and dispose of. You have said respondent number 2.
Respondent number 2. It is
My lord,
mentioned
2
in
and
the
4, my
order.
lord, may I
My
take
lord,
down
2 and
competent
4, my
authority?
lord.
No,
Four,
only
four.
2.
Four,
Only
four.
2.
4.
Yes, my lord.
To-
Where is 4?
All right.
2
Joint
and
Commissioner
4.
of Customs.
Joint Commissioner
How
of
can
Customs.
both consider? How can
My
both
lord,
consider?
My lord, Joint Commissioner of Customs need to
always-
consider
Are
this.
Bapre,
So respondent number 4,
Yes, my lord.
Respondent number 4.
the direction upon the respondent number 4 to consider and adjudicate the application dated 1st of April 2026, filed by the petitioner under section 110 capital A of the Customs Act 1962 within a specified time frame. Full stop. Considering the fact that the petitioner has paid for provisional release by submitting an application on 1st of April 2026, WPA number such and such stands disposed of by directing the Joint Commissioner of Customs Preventive Division, Alipurduar Customs Division, being the 4th respondent, to consider the application of the petitioner dated 1st of April 2026, filed under section 110 capital A of the Customs Act 1962, and dispose of the same by passing a reasoned order strictly in accordance with law as expeditiously as possible, but positively within a period of 4 weeks from
My lord, may keep it for 2 weeks. It's a humble request.
My lord,
4 months, my lord. May keep
Because
it for 2 weeks.
Calcutta adjudicating authority is in Calcutta. Kindly fix
So
it.
he is saying 2, you are saying 6. Average is
No,
4. That is what I have directed. So it
My
has
lord-
to be an average. So I know.
My-
He will be saying for a shorter time. He will be for a longer time. I know that because I have given the average time.
My
4
lord,
weeks from the receipt of a server copy of this order, together with a copy of the application dated 1st of April 2026. Full stop. It is however made clear that this court has not entered into the merits of the claim made by the petitioner, and
Without
all
going into the
points
merits of the.
and all points are left open to be raised and decided by the said respondent authority while passing the reasoned order. Full stop. Since a prayer for extension of time to file the reply was made by the was made by Mr. Bonik, learned advocate for the Customs Authority, and considering the
Illness of the.
limited prayer made by the petitioner, it is observed that the allegations contained in this writ petition shall not be deemed to have been admitted.
My lords, in the other matters, my lords has keep it for 3 weeks.
Assistant
My lords,
Commissioner
in
is
this
thereby
matter also,
dispensed
let it be 3 weeks, my lords.
regarding filing of the affidavit in opposition.
My
Yes,
lords,
yes.
In the other matters, my lords have given them 3 weeks. Let it be 3 weeks.
No, here 2 and 6 is average is 4.
My lords, in that case, they shall also give me that report.
My lord, regarding filing of affidavit, one line is required, so that the report may not be filed.
That is what I said.
My lord-
Allegations not to have been admitted. I have protected you.
My lord, let them
Yes, like
serve us the
affidavit-
report, my lord, without
report also, my
considering
lord,
the
so that-
report. We
Why
can't
they have not filed? Why
Yes,
they
I
will
am
serve?
filing.
No, my
Yes,
lord,
yes.
the laboratory report.
These are the laboratory report, they must give,
Yes,
my lord.
call the. ওইগুলো দেখে দিন। দেখে দিন। Item number 104. Yes. Who is appearing? Election dispute, election matter.
Yes,
SIR,
your
yes,
lordship, it's a
disposed of.
SIR matter.
Next.
Till 111.
Yes. Till 111.
112
No,
is a
not
different
till
matter.
111. 122.
Your lordship, 112 is a different matter. It's pertaining to some brick field.
112 is different.
Your
Oh,
lordship,
yes,
as it
112
appears
is
here.
pollution control. Oh, yes, yes. Except 112. 112 town pollution control. কি সব আছে?
104 to 108, your lordship. 104 to 108, your lordship.
104 to 1010.
104 to 108.
You are appearing.
Yeah, I am appearing.
All right. Next.
111, my lord.
111. All right. Give your appearances disposed of. Except 112. Who is appearing in 112? Call 112.
112.
You are appearing in 112.
Lordship.
Who is appearing in 112?
Lordship, would your lordship may kindly take up the matter tomorrow?
112.
112 he is praying for not today.
112.
All right.
112.
An accommodation has been sought for by the 112. An accommodation has been sought for by the learned advocate for the petitioner. Full stop. List this matter before the next available circuit bench. Yes.
113.
সবকটাই তো হয়ে গেল।
হ্যাঁ 13 to
113 দেখে নিন 113 to 122
22
disposed of.
SIR matters. Your lordship.
I'm for the petition.
SIR matter disposed of.
115.
Yes, disposed of.
116.
Disposed of.
117.
Disposed of.
118.
Lordship,
Disposed of.
118 to 21, lordship.
Disposed of.
120.
Disposed of.
121.
Disposed of.
122.
Disposed of.
Grateful, lordship.
My learned friends could provide the scanned copy if they haven't.
Yes,
Much
yes,
obliged.
that is there in the order.
Your lordship.
Yes.
My lord, may I mention if my lords may kindly permit?
Yes.
My lord, today item number 140 is listed. May I request either the same can be taken up? If not, maybe the same can be taken up on day after on board. If that is also not permissible, my lord, the third, just wanted to appraise, my lords, that on identical investigation, identical show cause notice, identical order was also heard by my lords on today itself. It was heard by my lords on today itself. An interim protection is granted.
140, what is this? 140, what is the item? What is the matter? What is the issue involved?
Yes, yes. No, my lord, what happened? The GST department had issued the show cause notice, which culminated into an order on the basis of a custom investigation, and there is absolutely no investigation by the GST department, and even there is no specific allegation. This is what number one. Number two, there is a jurisdictional aspect as far as bunching is concerned. That is the another aspect, and it is completely on borrowed satisfaction. They have not even identified what is levy on what they want to levy the tax. So, if may kindly permit, in the supplementary list, Learned Muralidhar sir has appeared on today, whereby interim protection was granted by my lords. So, this is absolutely same identical case. If the same protection can be granted, the respondents may take time to file the reply, which has not been done till now.
No, here the directions for affidavits was passed. Directions for affidavits.
Yes, my lord. It was passed on 30th June, my lord.
Yes. Yes.
I have received instruction from the department. Only 7 days time is required. How I read this.
All right, it will tomorrow I'm directing this matter to be upgraded. 140. Tomorrow I will take up.
My lords, may I humbly request, if my lords permit, for day after, I'll come in person there.
Day after is a problem, then it has to be next circuit bench. Then I can upgrade it in the next circuit bench.
And fine, my lord. Tomorrow I'll appear through VC. Then possibly.
Yes, no problem.
Thank you.
All right, you appear through VC, no problem. Yes.
Thank you, my lords. Thank you very much.
Yes.
Item number 21.
Yes.
Item number 21.
My lord, I'm for the.
Yes.
Yes, my lord, I'm for the petitioner, my lord. I have been tasked to give, explain why the alternative to the invocation of writ to decision. My lord, I will just wait and make my research, and I hope I will be able to satisfy your lordship that in the instant case, my case merits the intervention of the writ court. Now, my lord, Mr. Mishra, the learned assistant additional advocate general, has relied upon several case laws in support of his argument that the writ court should not interfere as there is an alternate remedy. Now, my lord, he has relied on one Supreme Court judgment and the rest are High Court judgments. My lord, I will deal with that Supreme Court judgment, that is Chabilas, income tax order versus Chabilas, and all the other judgments, my lord, that which I'm relying on are Supreme judgments, and I'm not dealing with the High Court judgments. Now, lord, before I go into it, let me, in a nutshell, say what is my dispute or challenge before this honorable court. My main challenge is to the jurisdiction of the adjudication order.
Ms. Mukherjee, you are not visible. Ms. Mukherjee, you are not visible.
My lord.
My lord, kindly bear with me.
Yeah, my lord, kindly. Am I visible, my lord?
No.
Then, my lord, why? My lord, am I visible now? My lord. My lord. My lord, am I visible now, my lord?
Yes.
Right. Okay. My lord, I'm extremely sorry, my lord, why this has happened. My lord, am I visible? My lord, am I audible? Nothing.
Yes, you are audible also. Audible, visible, both.
My lord, I am neither audible nor visible.
Yes, yes, you are audible as well as visible, both.
My lord, I'm just praying for a Passover so that I can. All okay. My lord, am I visible, my lord?
Yes, yes.
No. My lord, I cannot hear your lordship. My lord, kindly give me 2 minutes. My lord, kindly give me a 2 minutes time, my lord. I'm setting up, or shall I pray for a Passover for 5 minutes?
All right, Passover. Passover, yes, call the next matter. Yes, 22. Yes.
Yes, my lord, am I audible? I'm appearing for the petition.
Yes, yes.
Yes. My lord, this is a case that this was heard last week. Your lordship will kindly see the last order. There's a challenge against a detention order of a consignment that was intercepted and seized under section 110.
Yes.
And the detention
Yes.
order has been passed under section 110A. Now, what has happened is during the period of seizure, the department has taken samples, sent it for testing, and the test reports have come back negative. On the contrary, the test reports have said that the goods are of Indian origin. So the issue has arisen as to whether or not the Customs Act has any application to the case at this stage. Your lordship will kindly see page 61 of the writ petition.
Yes.
Your lordship will see the findings of the Arikanath Research and Development Foundation. The final conclusion has been provided in the last paragraph, and it says very clearly that they resemble Indian Arikanaths. Now, if your lordship sees the original detention memo in page 44,
yes.
This is annexure P3. Your lordship will see the detention memo is dated 24th March 2026. Your lordship will find this detention memo is not accompanied with any preliminary reason. So when the seizure took place, this is a classic case of fishing and roving, where they seized first, asked questions later. They seized the goods, then they sent the samples. Now the sample tests have returned with the observation that the goods are of Indian origin. So at this stage, the impugned detention order that has been passed in page 80.
Page?
80.
80, yes.
Your lordship will see there's no reference to their own test, the test report which they themselves have procured. Rather, they are referring to, this is in page 81. Your lordship will see the discussion and findings.
Yes.
So all they're referring to now is the Food Safety Standards Authority of India report, which says that the goods are not fit for human consumption. Now, the assessee can sell the goods for industrial use also, especially if the areca nuts are locally grown. There is liberty always available to the assessee to sell to the goods for industrial purpose. There's no necessity that they must be used for human consumption in any way. This order is passed by a customs commissioner. He's not a health officer under the health department. This is a provision under the Customs Act which is being invoked, and any food safety standard is not a basis for confiscation under section 111 of the Customs Act. So with their own test report, there is a major question as to what remains of the seizure, and how can the goods continue to be detained in spite of the report themselves that they themselves have procured, saying that these goods are of Indian origin. This is the prima facie case that I seek to make out before this honorable court. In this regard, your lordship will see this honorable court in identical circumstances has passed an order in the case of FMR Agro Industries. There's a compilation which I had submitted on the previous day. The very
Yes,
first,
yes.
The very
FMR.
first, yes, my lord. If your lordship sees the decision, it's an identical. The circumstances are almost identical to the circumstances of this case. Your lordship will kindly peruse the decision.
FMR টা আছে এখানে। Yes, yes.
In page 3, your lordship will see this honorable court as a condition precedent to the release directed that the petitioner submits an affidavit or of undertaking before the customs authority stating that the provisionally released nuts shall not be used for human consumption. I have instructions that a similar undertaking can be given in this case also if your lordship directs.
Yes. Yes. Yes, Mr. Bud.
As per direction given by this code in WPA 638/26, 638/26, the order was passed within of 2 weeks. Order regarding consideration of application for conditional release. That order was passed on 23rd June 2026. That is based on 180. Annexure P11. In the order, everything has been mentioned categorically. And point number 7, 8, 9, 10. It is mentioned that since the petitioner has failed to produce any document regarding procurement of metal nut, as well as the test report, which suggests that these are not fit for human consumption.
Mr. Bonik, who has sent these, please kindly come to page 61. Yes.
Reservoir of Indian area nuts. Reservoir, what happened?
So we have sent this sample to this Arikanat Research Foundation. Who has sent this? Yes. So are you not believing on this report? Where is your, you also did not consider this report while passing the order. Why? Please show. Please show how have you dealt with this report. Where you have considered, please show me.
There are 10.0.
Yes.
That is National Food Laboratory.
No, that is National Food Laboratory. This Arikanat Research. Where is consideration of this test report? Why they will prefer an appeal? Why they will prefer an appeal? One document you have sent, you have obtained that report, and you have not considered that. So only your grievance is that it is not fit for human consumption. They will submit an undertaking that will not be used for human consumption, for industrial use. What you will do by seizing, retaining those two goods? What purpose will be served? No, not reconsideration. This no reconsideration. No affidavit in opposition. How can you improve upon a reasoned order by way of an affidavit in opposition? Mr. Bonik, I'm telling you, I'm against passing mechanical orders for direction for passing affidavit in opposition. When a reasoned order has been passed, MS Gill is there, you cannot improve upon by way of an affidavit. So the reasoned order will be only tested. Where is the scope of passing and directions for affidavit in opposition? Yes. Yes.
The National Food Laboratory, Kolkata, has reported, report dated 22nd April 26, that the sample does not conform to the standard laid down under.
Yes, it's a substandard, unsafe for human consumption. Mr. Bonik, this says it's a substandard, not fit for human consumption. They will submit an undertaking. They will. It will not be sold in domestic market for human consumption. You will be protected
By the public in general.
Ashok, this application under Article 226 of the Constitution.
This is also my submission, para number 8, that in Indian article, the minimum value is of 351 per kg. But from the report of DGFT, it is clear that these articles were bought from outside India, that is Indonesia.
Where is that report?
8.0.
Where is that report?
The DGFT notification number 57 by.
Not notification, report.
My lord, the price was fixed in view of the notification number 57 by 1520. Where it is mentioned the minimum value of the alkaloid is 351 per kg. But in their challan, it is mentioned that 142 per kg.
If I may,
So,
my lord, that notification of DGFT
Yeah.
only applies when there is foreign origin. They must satisfy foreign origin. Without that, the DGFT notification has no application.
My lord, if you want the accommodation, I will submit the DGFT notification.
My lord, he cannot improve on the order. He cannot improve on the order.
Fix it tomorrow. I will fix it tomorrow. I will finally, I will submit the DGFT notification, wherein it is categorically mentioned, assumption that when a below the rate of 351, it amounts to 4 rupees. Kindly allow me one day accommodation. I will submit it.
My lord, that notification has nothing to do with this. Please.
Where is the notification? Mr. Bonik, for this it was adjourned.
My lord, I'll
Enable you to
explain the
revert back with
notification.
necessary instructions on 21st of July.
My lord, I'll
So
explain
today we
the
are on
notification.
29. No. You should be ready with those. This application under Article 226 of the Constitution of India is directed against an order dated June 23, 2026, passed by the Additional Commissioner of Customs, CCP, West Bengal, Kolkata, thereby rejecting the prayer of the petitioner for provisional release of the seized goods. Full stop. The when seizure was made,
22nd March 2026.
where do I get those facts?
I apologize. Detention memo is 24th March 2026, page 44.
Other. On 24th of petitioner dispatched a consignment of dried areca nuts and while in transit, the consignment was seized and detained by the second respondent under Section 110 of the Customs Act 1962 by issuing a detention memo where is the detention memo?
Page 44, my lord. 4.
Detention memo dated 24th of March 2026. Full stop. The samples were sent for testing before the Arikanat Research and Development Foundation by the Superintendent of Customs, by the concerned Superintendent of Customs. Full stop. The petitioner filed an application under Section 110 capital A of the Customs Act 1962, praying for a provisional release of the seized items. Full stop. Such prayer of the petitioner for provisional release, the prayer of the petitioner for provisional release of the seized items stood rejected by the order dated 23rd of June 2026. Full stop. Mr. Chakraborty, learned advocate appearing for the petitioner, submits that the test report of the samples sent to the Arikanat Research and Development Foundation indicates that the seized, that the Arikanat resembled the Indian Arikanats, and such nuts are good in quality. Full stop. He submits that, he further submits that the Additional Commissioner of Customs, while considering the prayer of the petitioner for provisional release of seized items, did not take into consideration such test report, but rejected the prayer of the petitioner by placing reliance on a test report dated 22nd of April 2026 of the National Food Laboratory, FSSAI, Kolkata. So, stop. He submits that the test report dated 22nd of April 2026 states that the seized goods do not conform to the prescribed standards and are unsafe for human consumption. Full stop. He submits that when the test report of the Arikanat Research and Development Foundation indicates that the seized articles resemble Indian origin, the foundational basis, there is the foundational basis of seizure is destroyed. Full stop. Paragraph. Now he further submits that the petitioners are ready and willing to submit an affidavit of undertaking before the concerned respondent authority that the said goods shall not be sold in domestic market for human consumption. Full stop. Paragraph. The learned advocate, Mr. Chakraborty, places reliance upon an order dated 3rd of July 2026, passed by a coordinate bench in WPA 850 of 2026 in the case of FMR Agro Industries Private Limited versus Union of India and others in support of his contention that on an identical fact situation, the coordinate bench directed provisional release of the seized articles subject to compliance of certain directions. First, a paragraph. Mr. Bonik, learned advocate appearing for the Customs Authority, submits that the test report of the National Food Laboratory, FSSAI Kolkata, states that the seized articles are of substandard quality and are unsafe for human consumption. First up, he further submits that the additional Commissioner of Customs, after taking note of the notification dated 14th of February 2023, held that the seized goods were not indigenously procured. So he submits that the yes, paragraph number 9 I have stated notification from paragraph number 9. Please see the last word. I have indicated that. I've taken note of paragraph 9. He submits that the said respondent authority passed a reasoned order, and for such reason, the court should not interfere with the said order. Just a paragraph. He further submits that the order under that an appeal he further submits that the order under challenge is an appellable one, and the petitioner can should be relegated to the appellate authority. First, a paragraph. Heard the learned advocates for the respective parties and peruse the materials placed. First up, it is now judicially settled that availability of an alternative appellate remedy cannot be an absolute embargo upon the High Court in exercise to exercise the power of judicial review under Article 226 of the Constitution of India. First up, it is the rule of exhaustion of alternative remedies is subject to certain well-known exceptions, and one of such exceptions is where the authorities have failed to exercise its discretion in a proper manner. Full stop. It is not in dispute that the Superintendent of Customs had sent the sample to Arikanat Research and Development Foundation for the purpose of testing the same. Full stop. It would be relevant to extract the test report dated 16th of April 2026 of Arikanat Research and Development Foundation. এটাকে এই করে দেন, observations and final conclusion. Observe final conclusion from the test report. Full stop. Content of the full stop. After going through the test report, this court finds that it has been specifically stated in the said report that the seized articles resembled to Indian Areca nuts and the nuts are good in quality. Full stop. After going through the impugned order dated 23rd of June 2026, this court finds that the said test report has not been considered by the Additional Commissioner of Customs while deciding the application of the petitioner praying for provisional release of goods. Full stop. It is well settled that a writ petition can be entertained in case where a relevant piece of evidence has not been considered by the respondent, by the authority while deciding an issue which falls within its jurisdiction. Full stop. The authority considered the test report dated. The authority only considered the test report dated 22nd of April 2026 of the National Food Laboratory FSS AI Kolkata insofar as the said seized article conforms to the prescribed standards as per the Food Product Standards and Food Additive Regulations 2011 and are safe for human consumption or not. Full stop. The test report states that the goods have been found to contain damaged nuts beyond permissible limits and are unfit for consumption under the Food Safety and Standards Act 2006. To stop at this juncture, it would be relevant to take note of the submission of Mr. Chakraborty, learned advocate for the petitioner, that the petitioner is ready and willing to submit an undertaking that the goods that the seized goods, if released, would not be sold in domestic market for the purpose of human consumption. Full stop. Thus, this court finds that there was in view of the test report issued by the Arikanats Purata, such and such, this court is of the considered view that the seizure of the consignment lacks the foundational basis, as the said test report has stated that the seized good resembles Indian origin. Full stop. Thus, full stop paragraph. The coordinate bench in a more or less identical fact situation held that there was no justification that there was no justification for the customs authorities to continue retaining the seized goods merely on the basis of the test report of the National Food Laboratory stating that the seized Arikanats were not fit for human consumption, when when an expert report obtained by the customs authorities themselves unequivocally indicates that the seized Arikanat resemble Arikanats of Indian origin. Full stop. For all the reasons as aforesaid, this court holds that continued detention of the seized articles is not warranted in the facts and circumstances of the present case. First of all, for such reason, this court is inclined to interfere with the order rejecting the prayer for provisional release. First up, paragraph. Accordingly, the order dated the order of the Additional Commissioner of Customs, CCP WB Kolkata, dated 23rd of June 2026, is set aside. First up, the writ petition stands disposed of with the following directions. Number one, the competent authority of the customs shall provisionally release the seized Arikanats to the petitioner in terms of Section 110 capital A of the Customs Act 1962 within a period of 4 weeks from the from the receipt of a server copy of this order, subject to the petitioner complying with all formalities in that regard
My lord.
within a period of 3 weeks from the date of receipt of a server copy of this order. Next, the petitioner shall file an affidavit of undertaking before the customs authority stating that the provisionally released arecanards shall not be used for human consumption and shall be utilized exclusively for industrial purpose. Full stop.
May I?
The next, the customs authorities shall be at liberty to proceed with the adjudication proceedings and conclude the same in accordance with law as expeditiously as possible.
Subject to furnishing bond, including.
I've said all formalities.
Now, within a period of 4 weeks.
3 weeks they will do. Within 3 weeks they will comply with all formalities. That is what I have
All
said.
formality, including furnishing bond,
All
bond, bank guarantee.
Furnishing of bond is the formality for release. I've said all formalities. What formalities you indicate to them?
Including bank guarantee. In the earlier order. it
Bank
was-
guarantee is not one of the formalities.
Yes, bank.
So I've said upon compliance of all formalities.
Yes. But if bank guarantee word is not mentioned, in that case, they will not produce any bank guarantee.
No, whether the statute provides for that.
On the earlier occasion also, on furnishing bank guarantee, it is mentioned in the, I think it is mentioned in the earlier order also. Bank guarantee.
I've said all formalities. Is it not a formality?
Yes.
Then
that's true. But bank guarantee is required. Without mentioning the bank guarantee, the petitioner sometimes they will not produce the bank guarantee.
it says necessary bonds, security, and other requirements. There also bank guarantee has not been mentioned.
All right. Security.
I've said all formalities.
Yes.
Acha, kore din.
Yes.
All formalities. That's all formalities not kore, subject to the petitioner furnishing necessary bonds, security, and other requirements, if any, to the satisfaction of the customs authority. I gave you more liberty.
Yes.
All formalities. You wanted to make all this clear. What?
Very grateful.
My
Yes.
lord, may I?
Yes,
take,
call the next
item
matter.
21, my lord. My lord,
Yes, call the
item
next matter.
21, am I visible, my lord?
is the next matter, my lord.
Yes. 21. Yes.
Yes, my lord. My lord,
Mr.
as
Bhumik,
I will
please take
state,
that.
my lord, that as,
Yes.
Yes, Mr. Ms. Mukherjee.
my lord, I'm visible and audible, my lord, both?
Yes.
Am I visible and audible? Yes.
Yes.
My lord, I tender my apology, my lord, for wasting your lordship's time by not being able to,
No.
my lord, operate.
No,
this.
you have not wasted.
My lord.
I've
There
finished
was a-
one matter in the. Yes. In the meantime,
My
I
lord,
could finish off
my
on
lord,
one matter.
as
Yes.
I said, my lord, as I was said,
How are you?
I was tasked to give say that why an alternative remedy will not be a bar
Ms.
for the
Mukherjee,
writ
now
court
you
to
are also
intervene in this.
not visible. You are not visible.
Why?
Yes, now you are visible.
My lord, am I
Yes.
visible now? Yes. My
Yes,
lord, could
yes.
be. I'll go further. Yes, my lord. Now, my lord, that is, I have to satisfy your lordship that my case merits the intervention of the writ court. Now, my lord, Mr. Mishra, the learned assistant additional advocate general, my lord, has relied on certain documents, certain case laws, and there was one case law that is income tax officer versus Chabil Das, which is a judgment of the Supreme Court, and all the others are of the High Court. Now, my lord, I will only rely on the Supreme Court judgments, and I will distinguish the case cited by Mr. Mishra. Now, my lord, before I place my judgments, in a nutshell, I'd like to say what has been my challenge in this application. That, my lord, jurisdiction. The jurisdiction of the adjudication authority to issue the show cause notice, being a member of the Bureau of Investigation and ITC investigation wing, and my lord, that he is not cross-empowered to adjudicate on matters which fall under the jurisdiction of the central authorities. And my lord, fourth is he has invoked section 74, which states that section 74 can be invoked when there is fraud, willful misstatement, or suppression of facts committed by the taxpayer. And there has been no such allegation against me. So if he at all had to adjudicate, it ought to have been done under section 73, which I had taken. So far as, my lord, the jurisdiction of the Bureau of Investigation, I did not take it in my petition, but I mentioned and I stated that I could take it at any step because it is a question of law. Now, my lord, in this respect, so my challenge is to jurisdiction, my lord. Now, my lord, in this respect, my lord, I am relying upon the judgment of Whirlpool Corporation versus Register of Trademarks. My lord, I think on the last occasion, this judgment had been submitted to your lordship. Does your lordship have it? My lord has it?
Whirlpool you have given?
Yes, my lord. Yes, my lord, or otherwise.
So Whirlpool is not
My
there.
junior is also there. My learned junior is there. Mr.
Yes, do you have a
Jalpaiguri,
copy
please
of
give Whirlpool judgment.
Yes. Yes. Do you have
My
a copy
lord
of
has it?
Whirlpool?
Yes, my lord. My lord, my lord has the.
Yes.
My lord has it? Yes, my lord. Now, my lord, I will explain in what background this case happened. My lord, Whirlpool, my lord had against Whirlpool, what happened, my lord, in Whirlpool's case, Whirlpool had applied to the Register of Trademarks for a certificate. Now, my lord, the private respondent, Chinart Trust, said that he was misusing his license, so his license should be cancelled, and therefore the Register of Trademarks they issued a show cause notice to him saying why his registration should not be cancelled. Now, my lord, against this notice, that is, Whirlpool filed a writ petition in Bombay High Court, which was dismissed. Now, against the dismissal of the writ petition, my lord, Whirlpool appealed to the Supreme Court. Now, my lord, I am placing paragraph 11 before your lordship as to what was the issue. Now, my lord, it says, Mr. Chagla in reply had submitted that where the action initiated by a statutory authority is wholly without jurisdiction, it can be challenged under Article 226 of the Constitution, and the writ petition cannot be dismissed summarily. Then, my lord, so he says that the registrar does not have the jurisdiction to proceed with it, only the High Court has. Now, my lord, in paragraph 12, the Supreme Court, being a bit humorous in the first part of the paragraph, might kindly come to 1, 2, 3, 4, the last 4 lines of the paragraph, my lord, 12. But before we do it, we will first dispose of the preliminary objection relating to the maintainability of the writ petition as filed in the High Court, allegedly being premature and having been brought without first exhausting the alternative remedies under the Act. So, my lord, the High Court had dismissed it because the alternative remedies were not aware of. Now, my lord, paragraph 13. Learned counsel for the appellant has contended that since suo motu action under section 56(4) could be taken only by the High Court and not by the registrar, the notice issued to the appellant was wholly without jurisdiction, and therefore a writ petition even at that stage was maintainable. The appellant in these circumstances was not obliged to wait for the registrar to complete the proceedings, as any further order passed by the registrar would have also have been without jurisdiction. My lord, my argument is also the same. Since the show cause notice and the adjudication order is without jurisdiction, any further order passed by any superior authority would be without jurisdiction. Now, my lord, I come to paragraph 15. And this is now the court's observation. Under Article 226 of the Constitution, the High Court, having regard to the facts of the case, has a discretion to entertain or not to entertain a writ petition. The High Court has imposed upon itself certain restrictions, one of which is that if an effective and efficacious remedy is available, the High Court would not normally exercise its jurisdiction. But the alternative remedy has been consistently held by this court not to operate as a bar in at least 3 contingencies, my lord. Namely, where the writ petition has been filed for the enforcement of any fundamental rights, or where there has been a violation of principles of natural justice, or where the order or proceedings are wholly without jurisdiction. So I submit, my lord, that my case falls within these 3 exceptions. One of these, that it is wholly without jurisdiction. Now, my lord, I thereafter go to paragraph 19, in which they are relying upon paragraph 19. Now, my lord, I will press this judgment in full. That is another Constitution bench decision in Calcutta Discount Company Limited versus ITO laid down. Though the writ of prohibition or certiorari will not issue against an executive authority, the High Courts have power to issue in a fit case an order prohibiting an executive authority from acting without jurisdiction. Where such action of an executive authority acting without jurisdiction subjects or is likely to subject a person to lengthy proceedings and unnecessary harassment, the High Courts will issue appropriate orders or directions to prevent such consequences. The writ of certiorari and prohibition can be used against the income tax officer acting without jurisdiction under Section 34 of the Income Tax Act. So, my lord, I have also prayed for a writ of certiorari. Now, my lord, coming to 20. Much water has since flown under the bridge, but there has been no corrosive effect on this decision, which though continue to hold the field, with the result that law as to the jurisdiction of the High Court in entertaining a writ petition under Article 226 of the Constitution, in spite of the alternative statutory remedies, is not affected, especially in a case where the authority against whom the writ is filed is shown to have had no jurisdiction or had purported to usurp jurisdiction without any legal foundation. My lord, both these conditions, my lord, apply to me. He did not have the jurisdiction, nor did he have the legal foundation, my lord, to usurp a jurisdiction under Section 74, when no element of fraud has been alleged against me. Now, my lord, 21, what does the court say? That being so, the High Court was not justified in dismissing the writ petition at the initial stage. That is, at the threshold, it could not be dismissed without examining the conditions that the show cause notice issued to the appellant was wholly without jurisdiction, and that the registrar in the circumstances of the case was not justified in acting as the tribunal. So in this case, my lord, the Supreme Court overruled the decision of the High Court for throwing him out at the initial stage without examining the contention whether there was the issue of jurisdiction. Now, my lord, another, my lord, I'm relying upon, which my learned junior will give a lordship, that is State of HP and others versus Gujarat Ambuja Cement Limited and others. My lord, this is a 3 judges bench, not even 2 judges, but 3 judges bench, it seems. Yes, my lord. No. My lord.
Ms. Mukherjee, have you
But I come
considered
to
my
paragraph-
judgments? Ms. Mukherjee, have you considered my judgment?
My lord,
which I have delivered.
I could not consider, I could not, my lord, get hold of it, but I am still relying on it to show your
All
lordship,
these
and
judgments are
thereafter your
taken into
lordship.
consideration. Do you have the Dhan Singh Nathmal's judgment, AIR 64 Supreme Court with you? Do you have PHR Invent Educational Society, the recent judgment, I think 2023 or 2024?
The question today is, if somebody faces
It's not, Ms. Mukherjee, I'm not for a moment disputing the proposition laid down in Whirlpool.
Yes.
So it's not that existence of an alternative remedy is an embargo upon the High Courts in exercising 226 and 227. And under 3 or 4 exceptional circumstances, it can be. One of which is where the challenge is that the jurisdiction, there is no jurisdiction.
Yes.
Or the authority lacks jurisdiction.
Yes.
That is one
Yes.
of the, well, I'm not disputing, Mrs. Mukherjee, those propositions. Those are elementary propositions. For those, you need not cite
Yes,
decisions
madam.
for the High Court. But the question is, when the one paragraph of Whirlpool you have just, you are placing, if there's an efficacious remedy available, whether a litigant should be allowed to bypass that. That's exactly Dhan Singh Nathmal's judgment, AIR 1964
After
Supreme Court.
availing 73 and 74.
And I am telling you,
My lord,
PHR
let me-
Invent, Ms. Mukherjee, PHR Invent takes into consideration this judgment, these well-known exceptions. I think I've forgotten the paragraph. Paragraph 32 has been quoted, recognizing those well-known exceptions. Next paragraph 33, the Honorable Supreme Court says, court should not entertain, that's the expression used, should not entertain writ petitions under those circumstances. So these are considering Whirlpool and all judgments. That is why I'm telling you. So now the situation has changed. I'm not for a moment saying that writ petition, the High Court cannot, but it's a question of discretion. When an alternative remedy is there, from their High Court, High Court's power is there. So if the High Court retains a jurisdiction at one stage, whether you should be permitted to challenge an order of adjudication. That's what is important. So I'm not, so you need not cite so many judgments on that. But the question is, after all, it's a question of discretion. If the court wants, no, there's an alternative remedy, it's not, it's a discretion of the court whether to entertain or not. Power is there, question of entertainability. I'm not saying it's not maintainable. That's the only point. Because I have considered these, all these, most of these judgments which will be relying upon up to Godrej Sarali. That also I have considered.
Yes.
Godrej Sarali also I have considered, telling you. That is why I've asked you yesterday, 2-3 months back, I've delivered 2 or 3 judgments, one after the other, on these issues, on the West Bengal Land Reforms and Tenancy Tribunal Act. And one of those is without jurisdiction. That is what your point.
Now my answer
Yes,
is that
yes, Mr. Rai.
alternative remedy.
Sorry, madam.
Yes.
25, what else do you want? I just,
Yes.
what is that?
The question today is that once the 73 and 74 proceedings were initiated, they took 107.
My lord,
So
I
they
have not
followed the act
finished.
as far as the first
My
appellate
lord, I
authority
have
is concerned. Then from 107, they will not go to
My lord,
112. So that is approbating and reprobating in the same proceeding. So I will follow the act to a certain extent, but after that I will come to the High Court and not go to the tribunal.
I will not come there.
All this, yes. So High Court's power is there. It's question of entertainability. Yes.
I will try
So,
to satisfy lordship. My lord,
but
2 judgments,
that is on a
2
different
judgments
footing altogether, because that is on Article 323B. So that tribunal stands on a different footing. I have also explained that.
Specified act.
Yes.
Yes, and that's a 320. Yes, 323A and 323B. Those fall in a different footing
We
altogether.
are misunderstanding outside jurisdiction and alternate remedy. Already is a discretion, outside
Yes.
jurisdiction is no more.
Discretion, it's the court's discretion because,
These are the hands now, but it's still all new point.
yes,
But
2025 4S.
My lord.
I think Godrej Sarali is after
My
that.
lord.
Godrej Sarali is after that. And there is
Yes, I
another
have read
judgment
Godrej
very recently delivered by Justice Dotto in the Supreme Court.
Yes. My
There
lord.
is some point which might help Ms. Mukherjee. There is some point, I do not know whether
My
she has
lord.
bought that
Godrej
judgment.
Sarali.
So, not Godrej Sarali.
My lord. I have
Not
got-
Godrej Sarali. Thereafter, there is another judgment also. So after that, there is also another judgment. Yes.
2025.
Ms. Mukherjee, only one thing, what I was, for what I was telling you, it's not that, it is.
My lord,
Yes.
can your lordship see me? Now, my lord, I will rely upon only distinguished Mr. Mishra's judgment, Chabil Das, and I will
No,
rely
Ms.
on a
Mukherjee, only one thing for what I was saying, there are various issues,
Yes.
including various factual issues also
Yes.
in your matter. So
Yes.
it's better you approach the statutory authority. It's better
My
you can canvass all
No.
your points there. And
My lord.
once you are taking the point of jurisdiction, if it is decided one way here, it might be difficult for you to canvass that there.
My lord,
Please consider
only,
that.
my lord, only allow me to produce 3 judgments. Only 3 judgments I'm varying. What? My lord, one is that
Yes, that's your.
he has spoke Chabil Das. Now, my lord, what was the issue in Chabil Das? Chabil Das to dekho? Oh, Chabil Das I have. My lord, Chabil Das, I will only. My lord, which he relied upon. Paragraph 8, right? Though? My lord, justice, page 739. My lord, my lord, kindly see what was the pleadings in Chabil Das. My lord, paragraph 8, which in Chabil Das, my lord, the writ petition was entertained by High Court. Now, my lord, paragraph 8, Sri Gaurav Banerjee will submit that the writ court was not justified in entertaining the writ petition since the SSC has invoked its jurisdiction under Article 226 of the Constitution of India, despite the availability of an equally efficacious alternative remedy under the Act, and therefore the writ court ought not to have interfered with the notices issued under Section 148 of the Act and the reassessment order passed by the assessing authority and the consequential demand notices issued therein. Or contrary, Sri Ganesh would support the impute judgment and order of the High Court. Now, my lord, on what basis Chabil Das was dealt with? My lord, paragraph 70. That is the only operative part. In the instant case, neither has the writ petitioner SSC described the available alternative remedy under the Act as ineffectual and non-efficacious while invoking the writ jurisdiction of the High Court, nor has the High Court ascribed cogent and satisfactory reasons to have exercised its jurisdiction in the facts of the instant case. In light of the same, we are of the considered opinion that the writ court ought not to have entertained the writ petition filed by the SSC. Now, my lord, this was the judgment relied upon by Mr. Mishra. Now, my lord, in my case, I have stated why the alternative remedy is ineffectual and non-efficacious. I have paragraph stated. I stated, my lord, kindly come to see. I have specifically stated, my lord. কত paragraph? My lord, I'm just reading it. My lord, paragraph 60 of my writ petition. My lord, I have stated paragraph 60 and 61. There is no other alternative efficacious speedy remedy available to your petitioner as the issues involved in the writ petition relates to jurisdiction, question of law, and there has been violation of principles of natural justice and miscarriage of justice, and the remedy sought for him herein is just and proper. Your petitioner submits that as the show cause notice and the adjudication order are without jurisdiction, your petitioner's case is a fit case for invoking prerogative writ jurisdiction of the Honorable Court under Article 226 of the Constitution of India. Now, this is what I have stated to show. I did say that the alternative remedy is not an efficacious remedy. Now, my lord, I will only rely on a Supreme Court constitutional bench judgment. My lord. Here, my lord, it is in a matter of revenue. And the argument which has been made by Mr. Mishra has been made there also, but the Supreme Court has rejected that argument. My lord, I'm placing. Paragraph 23.
Yes.
Yes.
Which
My lord,
judgment? Which judgment?
my lord, Calcutta Discount Company Limited versus Income Tax Officer, and that is a constitutional bench judgment of the Supreme Court. And it pertains to revenue, my lord, income tax. My lord has it, my lord?
Yes.
It must therefore be held, I'm reading the observation of the court. It must therefore be held that the income tax officer who issued the notices had not before him any non-disclosure of
Which
a
paragraph?
material
Which
fact.
paragraph?
Paragraph 23, my lord.
23.
Page number 10, my lord. Paragraph 23. Page number 10.
Yes.
My lord, it must therefore be held that the income tax officer who issued the notices had not before him any non-disclosure of a material fact, and so he could have no material before him for believing that there had been any material non-disclosure by reason of which an under-assessment had taken place. Next paragraph. We are therefore bound to hold that the conditions precedent to the exercise of jurisdiction under Section 34 of the Income Tax Act did not exist, and the income tax officer had therefore no jurisdiction to issue the impugned notices under Section 34 in respect of the years, etc. Now, my lord, kindly come to paragraph 27. What were the pleadings of the respondents before? That is, the pleadings of the income tax officer before the Supreme Court, which is absolutely akin to what Mr. Mishra has said. Mr. Shastri mentioned more than once the fact that the company would have sufficient opportunity to raise this question whether the income tax officer had reason to believe that under-assessment had resulted from non-disclosure of material facts before the income tax authority himself in the assessment proceedings. And if unsuccessful, there before the appellate officer or the appellate tribunal or in the High Court under Section 66(2) of the Indian Income Tax Act. My lord, it is similar to the argument pleaded by Mr. Mishra. The existence of such alternative remedy is not, however, always a sufficient reason for refusing a party a quick relief by a writ or order prohibiting an authority acting without jurisdiction from continuing such action. Now, my lord, 28. In the company says the conditions for the assumption of jurisdiction under our Section 34 were not satisfied and come to the court at the earliest opportunity. There is nothing in the conduct which would justify the refusal of proper relief under Article 226. When the Constitution confers on the High Courts the power to give relief, it becomes the duty of the courts to give such relief in fit cases, and the court would be failing to perform their duty if relief is refused without adequate reasons. In the present case, we can find no reason for which relief should be refused. So the question of alternative remedy of the hierarchy of appeals and the fora were considered, and the Supreme Court said that if there is a question of jurisdiction, it should be cut short at the initial stage. Now, my lord, I have one more. That is the coordinate bench in this case. My lord, I have placed before your lordship. Now, coordinate bench ki pass kore. Give me that. Yes, my lord, I have placed before your lordship an order dated 8/7/26 of the coordinate bench. My lord, in that coordinate bench, the coordinate bench was primarily the same question, that the bureau had no jurisdiction to pass an adjudication order. the coordinate bench, my lord, having considered, had passed this order. My lord, kindly come to paragraph 4 of this order. I had earlier also read out, my lord, what it says. Having regard to the aforesaid, my lord, may I read it from the beginning for your lordship's pleasure? Challenging the show cause notice issued by the respondent in his capacity as Joint Commissioner, State Tax Bureau of Investigation for the tax period under Section 73 of the Act, on the ground that though he has the jurisdiction to investigate into non-payment, short payment of taxes by virtue of notification dated November such and such, the same does not empower him to issue the show cause notice. That is what I have also, my lord, canvassed. Mr. Kanodia, learned advocate representing the petitioner, has not only drawn the attention of the court to the provisions of Section 73 of the Act.
Ms. Mukherjee, only one thing. This is an interim order. Interim order cannot be said to be a precedent. No ratio has been decided here. That's not binding.
Yes.
No ratio has been decided.
So, my
that's
lord,
elementary. That's elementary. Interim order cannot be treated to be a precedent, not binding. There's no finding, no observations here. So only it's an interim order, cannot be said to be a binding precedent.
my lord, if your lordship, but all I wanted to say, in identical case,
So
there
that's
was
not
a
binding.
stay, and my lord,
Only the coordinate being said that there is a jurisdictional issue, passed an interim order. Now the jurisdictional issue has been answered by Mr. Misro. He has answered in his own way. So here nothing was decided. It has not been held that they do not have jurisdiction. It's only an interim order which has been passed. It cannot be said to be a
I
precedent.
bow down to your lordship. If it is an interim order,
Yes.
but I am submitting that when there is no jurisdiction, my lord, I should not be relegated.
So what is your reply? Mr. Misro has replied to the point of jurisdiction.
No,
What is your reply to that?
Let me frame my question once again. There is a section 74.
Please answer to the point of jurisdiction which Mr. Misro has relied upon. He has relied upon several division bench judgments, considering your Madras
My lord,
judgment.
I said, my lord, Madras judgment, yes, that is the first one. My lord, yes.
No,
To
after that,
my reply is, my lord,
considering that a
yes,
different,
I'll give
different view has been taken by
my lord.
other high courts.
Yes, I will consider that.
So,
My lord, TVL, your lordship is talking about TVL. So far as TVL is concerned, my lord, the TVL is versus, my lord, the GST Council. Now, I would like to know, my lord, there are divergent views, but the GST Council, I have checked, my lord, and I have to find out, and I've checked that the GST Council Special Secretary has not appealed against this order before the Supreme Court. So I would say, they have not appealed before the division bench, nor before the Supreme Court. So I would say that they have accepted this principle. So that is would be my reply to this. Even though there can be divergent views.
That cannot also be a binding precedent upon this court.
No,
it may have
I'm
some
not saying.
persuasive value, cannot be
Yes.
decision of the Madras High Court, cannot be said to be binding.
Yes,
It may have some
my lord,
persuasive value.
my
So
lord.
it's also not binding. It's
My
also
lord, it
not
is
binding.
It is not binding.
Yes.
It is a persuasive value. But my lord, then
Yes,
let
yes.
the central
And there are
CBST say by way of an
decisions
affidavit.
of other high courts. Ms. Mukherjee, there
Yes.
are other decisions of other high courts
Yes.
against you. Against
Yes,
you.
yes,
So that
yes,
jurisdiction part,
My lord,
part goes. That is why I
but-
gave you liberty. If you want me to decide
No.
on the jurisdictional part, I can decide
That is
No
one
issues. If
jurisdiction.
that goes,
My
your
lord,
alternative remedy part goes.
no, my
Your
lord. My
alternative
lord,
remedy part goes.
No, my lord. My second point was that the ITC investigation unit. My lord, how could he? He is using the ITC investigation unit, which was not created under the WBGST Act, which was created under the West Bengal Value Added Tax Act, and which has been subsequently declared as illegal and a nullity. So, my lord, they have taken something which does not exist, which is illegal, and they have not applied or appealed against the order of the tribunal. My third jurisdictional point is that the Bureau of Investigation, who has issued the show cause notice, has no jurisdiction, and they have not been able to satisfy Mr. Mishra, from where does he get his jurisdiction when the commissioner by his order has only confined his jurisdiction to enforcement activities? My lord, and my lord, I'm placing that order. So how will he? I've got this order. My lord, if your lordship sees the order dated, it is the jurisdiction of the officers posted in Bureau of Investigation, dated 2011-29. Now, my lord, what is his jurisdiction? First two parts are the territorial jurisdiction. Mr. Mishra has not dealt with this at all. The officers, I'm reading paragraph 4. The officers posted in headquarters or zonal office of a unit of Bureau of Investigation shall exercise jurisdiction over any person, including a taxpayer, transporter, or a person in charge of a vehicle, irrespective of the specific location of the place of business of such transporter person, for carrying out enforcement activity, not, my lord, for adjudication. In respect of storage of goods, in what respect? That is also limited. Or transportation or movement of goods into, within, out of, or through the state of West Bengal, provided the goods are stored or the vehicle is intercepted within the territorial jurisdiction of the headquarters or zone of a unit of Bureau of Investigation in which he has posted. This, my lord, Mr. Mishra has not addressed. So he has the Bureau of Investigation.
Can we look into five? Five of the same.
Yes, 5. What does it say?
She has
Yes, I'm
read
looking
4.
to 5. I'm reading 4.
Also.
It says only for the purpose of investigation, including IT investigation, the
ITC
officers posted
investigation.
it only have jurisdiction for
ITC
investigation, but not with anything incidental to investigation. Nothing more than that. They can only investigate. They can investigate and pass their report to the respective jurisdictional officer. That is my submission. They can only make investigation. There is no order that they can, this particular wing can pass an adjudication order when I have a jurisdictional officer. That is, my lord. So it is absolutely palpably without jurisdiction.
Yes. Anything more?
And that is why, my lord, the coordinate. That is, my lord. That is.
Oh, all right.
And also, my
Yes.
lord, I have taken section 73, 74.
Yes. Yes. Mr. Mishra, anything more?
No, I think the.
All right. Heard the learned advocates for the parties. Hearing concluded. Judgment stands reserved.
Diploma.
Yes. Next.
I'm grateful, my lord.
Yes. Call the next matter. Yes. Call the next matter.
Item number 38.
My lord, I'm
38,
appealing for the
yes.
petitioner, yes. This matter, the lordship has already heard. It's a short point in
Yes.
SPCM. Very short point in here what has happened, adjudication has been done. There are two glaring defects. One, Shoko's notice did not consider the page 49 reply that I have given.
1 day accommodation, why?
My lord, this has
for my
been going on for the
preparation,
last 2 weeks. This has been going on for the last 2
No,
weeks.
no.
Yes.
Only the date was.
No, it is not about
24th.
only. It is
Matter
about
was
the matter.
on
The matter is a
23rd.
fresh matter.
And
It has been
just
doing its rounds
day
for the last
before
7
yesterday, I have received. I have to
Why?
take
Why?
instruction, my lord.
We have already given you
It is.
Day before, Mr. Boni, why day before? Mr. Boni, why are you saying day before yesterday? You appeared on 23rd.
My lord, on 23rd, my junior was appeared. At that point of time, no copy was served upon us.
No,
Ultimately, day
completely,
before yesterday, I have received.
completely
I have to take
baseless.
instruction. I am
It was
paying
given
for
to
1 day
them to
accommodation.
their office. I
Nothing
cannot
more.
serve it to them. I had served it to their office.
Only 1 day accommodation. Tomorrow I will have appear physically and I will make my
Kindly
submission.
appreciate this matter has been going on for 7-8 days.
And
Every day
my
this
lord
thing is
can
taken up.
fix it top
It's a
of the
very
list, my
small,
lord.
short matter, my lord.
Yes, yes. What is this matter?
My lord, it is
Yes.
page 49. This reply was never considered.
Which was on?
49, lordship, kindly. This was the reply.
Page 49, yes.
Thereafter, what they say in page 49, lordship, kindly see, the date is April 23, 2024, which was received by them on 24th April 2024. That much is clear. Now, lordship, kindly comes to page number, the focus notice, which is at page number
62. The relevant part will be 64. Yes, the relevant part will be 64. I'm referring to the last paragraph, paragraph 2.9. Lordship kindly sees what is written in last few lines. Thereafter, vide later dated so and so, the taxpayer submitted only a few documents and clarifications and requested further time to furnish the documents, clarifications under so and so. In response, the taxpayer was given one last opportunity to submit necessary clarifications and remaining documents via office letter dated 19/3/2024. However, thereafter, the taxpayer neither did submit any documents nor any clarifications were given. So, my letter 23, that was never done. This is number one, point number one. Now, Lordship kindly takes the impugned order of adjudication, which starts from page number 84, but the relevant portion is at page 96.
84. 96.
Lordship kindly comes to 96.
96.
Yes. 4.1 personal hearing I will be referring to. I'm putting it before you, Lordship. In terms of section so and so and following the principles of natural justice, the said notice was accorded opportunity of personal hearing before the adjudicating authority scheduled on so and so, and intimation in this regard was sent via letter dated so and so through speed post as well as through email. In response, the notice requested through email dated so and so to reschedule the PH on 3/6/2005. Adjudicating authority considered the request and allowed the PH on so and so. Accordingly, the notice was represented by Sri Anil Kumar Rastogi, CA, in the personal hearing held on that. The personal hearing was conducted in physical mode as requested by the authorized representative of the notice. He submitted authorization along with so and so things. He stated, my lord will leave 1, 2, 3 and 4 lordship kindly takes. It is requested to grant 25 days time for detailed submission, reply along with supporting documents. Now let me tarry here for a moment. All the documents had been given. Only one thing remained, that was they wanted a certificate from the customs. I had applied it before the customs. Customs said I will take 30 days. So 5 days were only gone. I said 25 days. After 25 days, customs is going to give me. So give me kindly 25 days. Now, my lord, the most peculiar part comes. They neither accept nor refuse such prayer. No further date of hearing is granted. And all on a sudden, they pass this order on 16th. This order was passed on. Yes, this order was passed on 16/3/2025. 16/5/2025 at page 84. 16/7/2025. And thereafter, Lordship will see what they are stating. 5.1. I have gone through the case records. Comprising of records. I find that notice has not supplied reply to the SCN. I have taken it on record. The oral submission of the authority representative on personal hearing held on 2005. However, I find that he has not submitted any document.
96.
If they do not give me a time, despite having it, I could not produce. Because once I am making them the prayer that kindly give me some time of 25 days, I will procure it from the department. I have already applied. It is a correction to be made by customs. It cannot be done by anybody else other than customs. Now, Lordship says they have proceeded against me by way of 74. Who am I? What do I make? I make railway sleepers. Can I make it a clandestine sale in the outward world? I cannot. It is the railway who purchases. I make the concrete sleepers between the two railway tracks. There are concrete sleepers. I make that. And now my thing was exported in Nepal, and that too by Indian Railways. Now that confirmation, government will not, the government gives confirmation, but it takes some time. So they requested 30 days. I said, there are 5 days already gone. So kindly give me 25 more days. Now they were supposed to either say yes or no. If yes, then when do I come? At what point of time do I come? Nothing was given. But this order was passed despite me supplying each and every document thereafter.
And a serious demand of around 14-15 crores, they have slapped upon my face. This is the whole predicament and this is the whole nicety of the matter. My only humble submission is I have all the documents. The authority, had he given me the time to produce that 25 days. The most peculiar thing is they waited more than 25 days. 25 days would have been over on 28th, but they waited more than that, and thereafter they passed the order. So they could have very well given me those 25 days.
Yes, Mr. Bonik, what do you say to this? What do you say to this? No, Mr. Bonik, the short point is that he's not saying that personal hearing was not given. So yes, given, but he wanted to produce some documents, which was the certificate of the customs authority. He has applied before the customs authority. Please kindly come to page 97. He paid before you for 25 days time because the customs authority said 30 days time will be required. So in the meantime, 5 days expired. He paid for 25 days.
Yes, but moreover,
So what was the difficulty in giving them 25 days time?
they have not included the DRC 07. DRC 01 has been enclosed together with the show cause. But DRC 07 regarding payment and penalty, that has not been mentioned. I have to take instruction.
All right, come tomorrow. Come tomorrow. Heard Mr. Bhattacharjee, learned advocate for the petitioner, on the prayer of Mr. Bonik, list this matter tomorrow.
Lord,
Yes, next.
Ascension in the list. It may be taken up a bit early. Lord.
Yes. Yes, yes. It will be higher up. Yes. Next.
Grateful.
Yes, Mr. Ghosh.
Your Lordship has substantially considered it on the
What
earlier
is this?
occasion, Millard, the dissolution of the municipality. Millard, I had placed the 3 orders which has already been passed by this honorable court. Robi Shankar Das, Millard, which is WPA 11873, squarely addresses the point.
Yes, Mr. Bhattacharjee, who is leading you?
Mr. Jagdish.
Where is he? He has deserted you.
One of the cases is under appeal. There were 2 appeals filed against the orders passed by 2 honorable coordinate bench. One might not is not surviving because it was dismissed for default.
Yes.
Other one might not.
No, is there any appeal from WPA 11834 of 2025?
To my knowledge, no, Millard. No appeal, no stay order. But the point is this, Millard, that when you are serving a show cause, referring to a particular material, that material had to be disclosed. And Millard, the entire decision-making process was done in extreme hot haste within 3 days. And the show cause does not disclose, neither the final order discloses that there was an opinion formed. That a board of councillor has become so inefficient or so negligent that it has to be dissolved.
Was any appeal filed against this order of 16 June 2025 in WPA 11834 of 2025? So if that is so, this is binding upon me. This judgment.
The facts in Millard.
Now you say so.
11873.
When it is against you, you are saying.
I will explain what has happened in this.
Millard, 11873 is Millard, on facts, Millard, it is more similar to our case.
11873.
873, Robi Shankar Das.
11873, there is any appeal.
First, if I can have my lordship for a moment on the facts of the case, and then we'll see what the judgment that has been relied upon.
No, I'm asking you, please let me ascertain whether there is any appeal against these judgments. Because Mr. Ghosh is relying upon certain judgments. According to him, these are on similar points. You may say it's different, but the question is, I want to know whether there is any appeal, whether there is any order of stay in this.
Facts are completely different.
All right, that I will consider. So I'm asking you whether there is any appeal, whether there is any stay of these orders.
State was to prefer an appeal, I need to ascertain whether that.
So till date, there is no stay of this operation of these orders.
Of none of them.
Stay order next.
One of them has been appealed. That was dismissed for. But what I am submitting today, my lordship, what I am submitting before my lordship is, if I can have my lords for a moment. Or what the fact.
One appeal is pending, but no stay has been there.
No stay order.
Yes.
Now what the facts are given. So I can have my lordship for a moment. On page 22. In total, in Alipurduar municipality, my lord, there are 20 councillors. The list of the councillors is there in page number 12. At page 22, there was a so-called notice that was issued. The so-called notice was issued by the executive officer on 1st of July 2026. The facts are completely different, and I will address one. On 1st of July 2026, to the councillor of ward number 20. What does it say? With reference to the subject and reference number cited above, please find here with a copy of the order received from the additional chief secretary, such and such. In this connection, you are to take necessary action as desired within 3 days from the issuance of the order or receipt of this order. What is that order, Lord? Page 23. This is what is there in the writ petition, and then I will come what the actual facts are. The district magistrate Alipurduar, by memo number such and such dated 27/6/2026, has sent a letter received from the executive officer Alipurduar municipality. The executive officer is sending a letter, and from which it has been learned that the chairman and the vice chairman of the Alipurduar municipality have submitted their resignation. So who resigns? Both the chairman and the vice chairman has resigned. Resignation letter is dated 18th of June 2026. This date is important. So on 18th of June 2026, the chairman and the vice chairman, they have both resigned. And no meeting of the board of councillors have been convened till date. So what is happening? The board of councillors have to convene a meeting. That meeting hasn't been convened till 30th of June 2026. So from 18th of June 2026 till 30th of June 2026, the board of councillors, they couldn't convene a meeting. Now who are the board of councillors? All the 20, and there are certain other people I will come to. As required under the provisions. So therefore, there is a stalemate situation. I will go a step ahead today and say that it is not only a stalemate situation, it is a lame duck situation. And this particular incident that has been narrated here, this is a casus omissus. Because even in the act, this has not been addressed. And I will come to that now. Whereas the resignation of the chairman and the vice chairman may likely render the business of the municipality non-functional so far as providing the civic services as per the constitutional mandate are concerned. I will come to what the constitutional mandate is, what is there in respect of the panchayat, what is there in respect of the municipality, what are the civic services that needs to be provided, that also I will address. And whereas consequently the reported incident of resignation of the chairman and the vice chairman, as mentioned above, will severely cause impact to normal function of the board of the councillors. Following statutory method laid down in Municipal Act and to discharge the duties imposed upon it, upon whom? Upon the board of councillors, or under the said act and the rules made thereunder, or any other law for the time being in force. Therefore, in exercise of the power conferred under, so 431 has been applied. Why 430 not applied? Why 431 applied? That is also something that we will address today. The governor is pleased hereby to direct the board of councillors of the Alipurduar municipality to show cause. Who is being show cause? The individual councillors are not being show cause. It is the board that has been show cause. Why the board has been show cause? That also I will explain. And show cause within 3 days from the date of issuance of this order, why it should not be dissolved on the ground mentioned herein above. Now, this show cause notice was sent to all the 20
Municipal, West Bengal Municipal.
That was sent.
Yes.
The reply to the first show cause notice. This reply is rendered by the councillor of the ward number 20. Reply to the show cause notice. What does this say? She is replying to it in his or her independent capacity, not as a board. They cannot represent the board. The board is a very large thing. So the board is a superset. They are all the subset thereof. So, with reference to the show cause notice, I am representing the ward number 20. What does the councillor say? Because all these councillors will find the reply is all stereotype. Same reply. What does the councillor say? I acknowledge the resignation. First point. They say that I acknowledge the situation arising out of the unexpected resignation of the chairman and the vice chairman of the Alipurduar municipality on 18th June, which has temporarily impacted the administrative functions. So in reply to the show cause, all of them are agreeing to this fact that unexpectedly the chairman and the vice chairman, they have both resigned, and because of such resignation, not that it is temporarily impacting the administrative function. Readiness to democratic resolution. They say that as a councillor, because I have been elected, so therefore, for my ward at least, I being a elected representative, I say that I am willing and ready to perform my functions. The show cause was issued against the board. Herein, the individual councillors, they reply. What it says, as a responsible representative of the people, I am completely committed to preventing any long-term administrative stalements. I am fully prepared and eager to participate in the urgent official meeting of the Board of Councillors to democratically elect new chairperson or vice chairperson as the provision. Then public interest against dissolution. The dissolution of the entire Board of Councillors would severely disrupt the ongoing civic amenities, public welfare schemes and essential development projects, and therefore, I earnestly request the higher authority to grant the Board of Councillors the immediate opportunity to convene a meeting. They are requesting the authorities to grant an opportunity to convene a meeting. Now, I can go through the others also. For example, as page 25, this is the councillor of Ward 3.
Same,
yes. He is also representing on behalf of Ward 20.
Yes.
So that is a typographical error. Then what happens? I will straight away take my lordship to page 28.
Yes.
The authorities, they issue another order at page 28. This order is dated 7th of July 2026. So, my lord, recall the initial resignation was on 18th of June. Now, on 7th of July 2026, the executive officer has given an intimation. It says, I am directed to inform you that the government of the West Department of Urban Development and Municipal Affairs has dissolved the Board of Councillors of the Alipurduar municipality with immediate effect under the provision of 431 has been applied. Subsequently, by order of such and such of 3/7/2026, the subdivision officer has been appointed as an administrator. And therefore, the Board of Councillors shall dissolve. All power and functions of the municipalities are henceforth be exercised by the administrator. The detailed order is at page 29. Whereas the district magistrate, Alipurduar by memo number such and such, dated 27/6/2026, has sent the letter by memo number such and such dated of given date received from the executive officer, Alipurduar municipality, and from which it has been learned. So, the letter was received from the executive officer. Nobody from the board or nobody from the councillors, they didn't intimate the authorities. Executive officer municipality, it has been learned that the chairman and the vice chairman of the Alipurduar municipality have submitted their resignation on 18th June and no meeting of the councillors has been conveyed till date, as required under the provisions of the West Bengal Procedure and Control Rules 1995. Then the third paragraph. And whereas, considering the severe impact of the reported incident of resignation of chairman and the vice chairman of Alipurduar municipality on the said municipality, as mentioned above, the normal functioning of the Board of Councillors of the said municipality following statutory methods laid down. I will come to what the board was supposed to do. Laid down in the West Bengal Municipal Act and to discharge the duties imposed upon it by or under the law for the time being, for the Board of Councillors of the said municipality has been directed by the within 3 days the reply was sought from the Board of the Councillors. And whereas executive officer Alipurduar municipality by memo number 493G dated 1st of July 2026 has served the show cause notice to all the councillors. So all the councillors were served with the notice on the same day. And whereas neither any reply from the Board of Councillors has been received. Now I will explain what is the meaning and purpose thereof is. We were not looking for replies from the councillors. We were looking for a reply from the Board of Councillors. And the Board of Councillors, they never replied of the said municipality, nor for any councillor has been received by the department within the period specified in the said show cause order. And whereas the Board of Councillors of the said municipality is not in a position to carry out the function and do normal civic services. The state government is of the opinion that the Board of Councillors of the said municipality has shown its incompetence in the performance of the duties and in exercise of the functions imposed upon it by or under the said act, the rules made hereunder and in the law for the time being in force. And therefore, the authorities declare the board of councillors of the Alipurduar municipality to be incompetent to exercise the statutory function imposed upon it and to dissolve the said municipality with immediate effect. What is also important to note is the next page, page 31. Because what the authority did was, it didn't simply dissolve the board and appointed an administrator. It has also given an option, and that option, Lord, is important. I'm only relying upon the last paragraph now. Now, therefore, in exercise of the power conferred by the subsection 3 of section 431 of the said Act, the governor, for the purpose stated above, is pleased hereby to appoint the subdivisional officer Alipurduar as the administrator of the Alipurduar municipality with immediate effect for a period of not exceeding 6 months or until the newly elected board of councillors take over charge, whichever is earlier. So this is a stopgap arrangement that is being done. For what purpose? So that the immediate civic amenities may be provided. And it is for a period of 6 months. And within that 6 months, the board of councillors, that they can any time come and they can say that no, we are united as a board of councillors and we will give the civil amenities. Now, what the law, my lordship, on this topic? But before that, if I can have my lordship for a moment on the 3 judgments that they have relied upon. The first one is 486 of 2026, Mysura Begum.
No, you can place the provisions, then we can come to the orders.
Now, how these are differentiated?
No, difference, I accept that. Please kindly come to the
In
provisions.
these cases, the chairman and the vice chairman hasn't resigned. There was a mass petition based upon that mass petition.
All right.
And electorally, democratically.
All right, please
elected.
show me the provisions.
Yes. Now, if I can have my lordship for a moment on what the provisions are. And in my case, and in that I am arguing to you, none of the provisions are applicable. It's a very bad situation. Let me explain to my lords. First of my lords, on 18th of June 2026, the resignation happened.
No, you have invoked 431.
We have
Please.
invoked 431. And
Yes.
why we have invoked 431?
Yes, please kindly come to 431.
Before that, there are three different situations that can happen. The first situation, my lord, says that the chairman resigns. And I will come to the statutory provision. What happens if the chairman resigns? The chairman, my lord, he hand over his resignation to the vice chairman. And the vice chairman.
Mr. Mistro, we cannot expand that because only the scope of the writ petition, please kindly come to this. The scope of the writ petition is the order dated 30th of June 2026.
My lordship.
So wherein you have invoked 431(1). Please show me that the conditions of 431(1) was present in this case.
In order to show that, I will just rely upon a couple of documents. And then I will explain what has happened.
Yes.
On 18th of June, the first page, this Mampi Adhikari happens to be the vice chairman. She gives a resignation.
So what is this? What are these documents which you are placing?
Yes. Because I said these documents are not there with the writ petitioner. So that is why I am placing it.
No, then you have to give him copies of this also. Otherwise, he will not be able to reply to this. Unless you give him copies.
Has to be.
Yes.
First page, Milo. On
Yes.
18th of June, the vice chairman, Mampi Adhikari, she submits a resignation. She submits it to the chairman. She says that in pursuance of 21B of the West Bengal Municipal Act, I hereby tender my resignation from the office of the vice chairman. Now, in a normal circumstance, if the vice chairman resigns, what is the provision of law? The provision of law for the Municipal Act is that the chairman has to elect somebody as a vice chairman. A meeting has to be convened and the election of the vice chairman has to happen.
Now the chairman also resigns.
Yes, in this case, what happens is that the chairman, he accepts the resignation of the vice chairman and then he resigns. So today, what is the situation? And not only that, the chairman was asked to convene a meeting of the board of councillors so that his resignation may be accepted and ratified there, because there is a provision of ratification. He does not turn up.
Who does not turn up?
Chairman. He does not turn up. He
Yes.
said, I am not interested. Because
Yes.
of different reason, I am not interested. In those situations, my lord, we know what will happen if a chairman resigns. We know what will happen if the vice chairman resigns. We know how the chairman can be replaced. We know how the vice chairman can be replaced. The Act nowhere says what will happen if both the chairman and the vice chairman resign, if the vice chairman submits the resignation to the chairman and the chairman accepts it and then he runs away. Because when the legislation was drafted, this kind of a casus homicis, it was never thought of. If I can have my lordship for a moment on the 17.3 of the Act.
Section 17(3).
17.3 of the Act.
Yes.
And I will explain what has happened in this case. And that is a very precarious situation because we do not know what to do. 17-3. It has never happened before, my lords. Election of chairman. I am not troubling my lordship with the first portion because it is the first time election that is happening. We are here concerned with 17-3. What would happen if there is a casual vacancy that is happening? In case of any casual vacancy in the office of the chairman caused by death, resignation, removal or otherwise, the board of councillors. So what action was to be taken? And I will come to the rules also. The board of councillors had to take an action. What was that? In accordance with such procedure as may be prescribed. The procedure is prescribed in the rules. Elect one of the councillors to fill up the vacancy. So what was the board of councillors? What was it supposed to do? The chairman has resigned. The vice chairman is not there. Only 17-3 is the only applicable provision that is there. No other provision will apply. So in that case, the board of councillors, they had to convene a meeting. When that meeting was to be convened? That was to be convened, my lords, as per rule 6-2A.
Rule ta ache ekhane? Municipal rules ta ache? West Bengal municipal rules. You have a copy of the rules.
I will hand over my copy. I recall what is there. So, as per 17-3, the board of councillors had to do certain activity. That activity is mentioned in 6-2A. 6-2A, my lord, says that within 7 to 15 days, the board of councillors, either the chairman had to call a meeting, and if the chairman or the vice chairman is not there, then the board of councillors should have called a meeting 7 days up thereafter, which means in total 21 days. In this case, what happened? Not only that the vice chairman resigned and submitted his resignation to the chairman ran away with the resignation. The board of councillors did nothing for 21 days. Complete stalemate. So the duties that were due to be performed by the board of councillors, they derelicted in that duty. Because 6-2A says, my lords, that after 15 days, there is a further extension. Maximum extension of 7 days and not beyond that. So for 21 days, something was to happen. Now from 18th of June 2026, the first 15 days, my lord, is over on 3rd of July 2026, and the second 7 days is over on 10th of July 2026. No meeting was convened. Based upon such situation, what was the option that the authority had? We always propose the board of councillors. So if I would have been one of the councillors, what I would have done? I would have collected all 20 of them together. I would have said that as of 51A, at least 1/3 is the quorum.
One
So
thing.
out of 20,
Mr. Ghosh.
and then I will.
One thing is these facts. Let them bring on record by way of an affidavit.
Millard,
Otherwise,
I could not get your lordship, Millard.
With regard to these facts, because Mr. Mishro is producing certain documents and certain materials,
yes, Millard,
which you may not be having a copy.
Yes,
Let him disclose this by way of an affidavit, because otherwise it might be difficult, because some rules he'll be relying upon.
Millard, I can respond on it.
On this.
Yes, I can. If your lordship, Millard, calls upon me, I can respond here and now.
But these documents, unless he brings on record, please consider
This,
the
Millard,
effect.
we are not disputing the documents. We are not disputing the documents. It's an admitted fact that on 18th June 2026, the chairman has resigned. And prior to him, the vice chairman has
No,
resigned.
you have seen the document.
Yes.
All right. Yes.
Yes. So what I was saying, my lordship, is that as per rule 6-2A, within 7 to 15 days, the board of councillors has to do certain activities. Because if they do not initiate it or if they do not do it, then in that case, a stalemate situation would arise. Because it is not the chairman or the vice chairman, therefore the rule 6-2A further provides for a further extension of 7 days. Neither in the first 15 days, nor in the extended period of 7 days, nothing was done by the board of councillors. And because nothing was done by the board of councillors, we are today in a situation wherein nothing can be done. The only option, if they had been better advised by the whosoever advised them in the district, was that the 20 councillors, they could have came together and they could have said that as per 51A of the Act, 1/3 is the minimum quorum. So let's do something. 1/3 of 20 is 7. So at least 7 of us, let's put together an application. If not 3, at least 7 of us, let's put together an application for calling for an urgent meeting. To whom? Amongst themselves for a board of councillors. They never did that. And the show cause notices were served to the board because we are concerned with the board, not with the individual councillors. Because
Show cause
individual
notice was served to
councillors
the-
that form the board.
Show cause notice was issued to the board. Please
Yes,
show me
my
that.
lords. If I can
Please
have my
show me
lordship for a
that.
moment on the show cause notice.
Yes.
I just placed it before my lordship.
Yes.
It has to be, it has to address to the councillor. But what the content was, that is important. Not to whom it was addressed.
Yes.
What is it that the authority wanted to know?
Show me the show cause notice.
Page 23, my lords.
Yes.
Whereas the district magistrate, I have already read it, my lords. The third paragraph. And whereas consequently, the reported incident of resignation of the chairman and the vice chairman, as mentioned above, were severely caused impact to the normal function of the board of councillors following statutory method laid down such and such. Now, therefore, in exercise of the power, please hereby direct the board of councillors of the Alipurduar to show cause within 3 days. The last paragraph. Now, who are the board of councillors? All the councillors, they are member of the board of councillors. Today, if I have to serve a notice to the board of councillors, how do I do that? Because the chairman is not there. The vice chairman is not there.
That is what I wanted to know from you.
Yes, my lord.
now you can proceed.
Because the chairman is
Now you
not
can
there.
proceed. Yes.
The vice chairman is not there.
Yes.
So I have to give it individually. I gave it individually. That also there is in the statement of facts. What I did
So
was,
you can give it individually, but they have to respond jointly.
because they have to respond as a board. And the
But you
response
can
was,
give it individually.
the response was asked from the board.
What prevented you from giving a notice to the board?
The board was not functional. Because what is it that the board
It's
consists
only
of?
one thing. When you say,
My lordship.
I do not recognize you individually, the notice also has to be to the board, not to individual. Because
The board is not there.
once you say, yes.
The board is
So if you
non-functional.
say that, if you say that, the second question cannot come. You are saying, yes, they cannot give reply.
I cannot give a notice to a non-existent board. The board is gone.
All right. Yes.
The board is gone. Now what I do is, if I can have my lordship for a moment,
Board goes when? Board goes
when the chairman and the vice chairman resigns.
Where is the provision? Show me.
Yes. If I can have my lordship for a moment.
Yes, yes. If
That
the
is there.
chairman and the vice chairman goes,
Yes,
board
yes.
is dissolved.
Yes,
Please show
yes.
me.
No, the board is not dissolved.
Then
It
the
becomes
board
defunct.
is always there.
It becomes defunct.
Show me the provision.
Section 14. Section 14. What is the constitution of the board first?
Yes.
What is the board of councillor consist of?
Yes.
The councillors elected in general election or by election of a municipality and the members nominated, they are the board of councillors. The board of councillors, unless dissolved earlier,
Yes.
shall hold office for a period of 5 years.
So
In a newly constituted municipal area, who represents the board is important.
no, please show me that chairman, vice chairman resigns, board dissolved. Please show me the provision.
Yes, yes. In the case that extension of administrative, the part of function vested in the municipal authorities, the board of administration. 4. If for any reason it is not possible to hold the general election, that is for general election, board of administration dissolved or under such an
5 years in subsection 2.
Yes, yes, yes,
Before the expiry of 5 years.
yes,
Then it will be dissolved.
yes. Yes. Section 16.
Yes.
The chairman shall be the executive head of the municipality and the municipal administration shall be under his control. He shall exercise such power and functions as conferred by him under the act. The chairman shall preside over the meeting of the chairman in council as well as the board of the councillors. So now the chairman resigns. Then what happens?
You
The
are
vice
saying
chairman has to.
that when these two resigns, board gets dissolved. Please show me the provision with regard to the dissolution of the.
No, there is nobody who is heading the board now.
Show me the.
Yes.
That's the
So,
effective dissolution.
my lordship. So if the chairman
Provision,
resigns, if
There's
the
no
chairman
statutory
resigns,
provision for that these two persons
No, no,
resign, it gets dissolved, subject to correction by.
well,
you.
no,
There
no.
is
What I'm saying, my lord, is The chairman is the presiding officer of the board.
That's a different thing altogether.
The chairman has
What you
resigned.
are saying, board is non-existent. Since the chairman and the vice chairman resigns, there's a provision in the statute subject to correction by you with regard to that.
No, no, it has to be seen differently. What I'm saying, my lord, is that the chairman is
According to you, if the chairman and vice chairman is not there,
nobody can
is
preside
there to-
over. Nobody can preside over the board.
But the board is not.
Nobody
dissolved.
can preside over the board. Now,
Board
in
is
this
not
case,
dissolved.
there are three things that could have been done. The first was what the chairman could have done was he couldn't have resigned. Instead of vice chairman, he could have appointed somebody else. Or the vice chairman. Those situations are gone. Those situations are gone. Today, the authority had two options. Either to invoke 430 or to invoke 430.
Let us come to that.
Yes,
430 and 430.
Now, if I can have my lordship for a moment on what is the difference between 430 and 431.
Yes. Let us
And when-
go to
and when they have to
431, then we will come to 430.
Yes.
Because 431
Yes,
you have
yes.
invoked.
Yes, yes.
So
yes,
let
yes,
us see whether
yes.
431, the requisites are present on.
Yes, yes. And those are the only provision. Otherwise, there is no other provision.
Yes.
Power of the state government to intervene in case of gross neglect or serious irregularity.
Yes.
Now, gross neglect of whose? Of the board of councillors,
Yes.
not of the councillors.
Yes.
If, in the opinion of the state government, the board of councillors have shown gross neglect. How they have shown gross neglect? 15 days plus 7 days. They have already passed, no meeting convened. Chairman, vice chairman resigned. If in the opinion of the state government, the board of councillors has shown gross neglect in the performance of duties imposed upon it by or under this act or any other law for the timing in force, or has committed serious irregularities in the performance of such duties, the state government may by order direct the board of councillor to show cause within the period specified in the order. We have given a show cause for 3 days. And that too after the period was over. Why it shall not be dissolved? On grounds of charges mentioned in the order. If the board of councillors fail to answer the charges within the period specified, so the answer has to come from the board of councillors specified in the order or within such further time as may be allowed by the state government, or if the answer do not convince the state government, or where more than 2/3 of the total number of the councillors holding office for the time being have for any reason resign, the state government may dissolve the board. So this, my lords, is the provision here. When the order of dissolution has been
So
passed,
this is the consequential effect.
yes,
So
yes.
you have, we have to see that.
We have
431
seen it. We have seen it that non-convening of the meeting 15 days plus 17 days, non-convening of the meeting is a gross neglect because they have neglected it within the meaning of 431. And therefore, my lord, the administrator has been appointed. Even today, if they come together, at least 8 members, because 7 my lords happens to be the minimum quota, or 7 members, then it will always be looked into.
Where is the scope? Where is
The minimum
scope
quorum,
in-
51,
No, no, no.
51A.
Where is the scope in view of this order?
No, because the last page that I have shown to my lordship.
Yes, show me that there's a
Yes,
scope.
Election now.
Please show me that there's a scope now. What you are saying.
They have committed a neglect, and that is why this order has
No,
been
no, that
passed.
is one
And-
thing. You are saying if 7 persons now come, that can be done. Please show me this from the scope of the order.
Or the newly elected board of councillors take over the
So
charge.
that will be the new election will be had. So they cannot.
No,
get-
no, a new chairman and the vice chairman has to be elected.
Mr. Are you submitting that? I record that, your submission, that if a newly
Who will
elected,
preside over the board?
that they will decide the remaining board. If you say that, I take your submission, I record that.
They have dissolved the board, no board today. What is he saying?
Please make submissions, taking some responsibility. If you say that, I record that and leave the board of councillors free to take steps. If you say 7 persons can come, then this order will go. If you are making that submission on instructions, I can record that.
No, no, the instruction, my lord, is
Then your order speaks otherwise. You are making a different submission now.
no, that is the understanding of the order, my lord, that is
No,
there.
no. Please show me. How can it be understood?
Or
in that
until
way?
the newly elected board of councillors take over
What
charge.
is the newly elected board? Newly elected board of councillors. How the board of councillors are elected? Has to be by way of an election. It's the newly elected board of councillors, Mr. Misro. It's not a newly elected chairman or vice chairman from amongst the existing boards.
No, the chairman is the
So if you
presiding
say
officer.
that, I record your submission. If you say that, yes, 7 persons from the existing board can come, this order will go.
No, on that, my lord,
That will
I
be end of the matter.
I will have to take further instructions from that.
Yes.
That was my
The order
understanding.
does not say so, Mr.
That, my lord, was
That's
my
not-
understanding of the order.
Could not have been. Could not have been the. And if you say so, I record that. I give the leave free for the board of councillors. If they choose, they will go and this order.
As on today, my lords, the situation is that we had no other option. Rather than taking the action, that action has been taken. Because the statute, it never, my lords, contemplated a situation wherein the vice chairman would resign and the chairman would accept the resignation and then he will also resign without calling for any meeting. That is a casus homicis. That is not there in the statute. That situation was never contemplated. And therefore, 431 has been invoked. Today, if the President of India submits his resignation to the Vice President, and the Vice President also resigns and runs away, then who will run the country? That provision is not there in the Constitution.
There is that in the statute.
No, the Speaker has to. The Speaker has
that
to.
in the statute. I will give that answer in the judgment. If you want that, I can give that answer in the judgment. There, I've looked into those provisions. While you are placing, I've looked into those provisions.
My last submission, my lord, would be
Submissions,
that the
everything
judgments
is
that
there.
has been relied upon, they are completely on
Everything
different
is
facts.
there. Because the statute, when the legislature thinks of frames of statute, they thinks in all lines. Statutory provision is there.
No, I couldn't figure it out because I have gone through the statute. I
While
have
you are
gone through-
placing, the provisions you are placing from there, I have got. I have not read any other provision. While you are placing, I have got that.
Then also, whatever order will pass, will pass.
No, that is the different thing altogether. So,
The judgments that they have relied upon, they are completely different. In those cases, the chairman and vice chairman hasn't resigned. A democratically elected municipality, my lords, on the basis of a mass petition was dissolved. Here in the situation is completely different. There's a difference
Please,
between external influence and internal subversion. Herein it is a question of an internal
Yes,
subversion.
which judgment? Please take it one by one.
Yes, my lord.
Please take
The
it
first
one-
judgment, my lords, that is 486 of 2026, Mysura Begum. 86 of 2026, my lords, Mysura Begum. In the first paragraph,
yes,
the Board of Councillors of the Jangipur municipality is incompetent to exercise work based upon what? Paragraph number 6, my lords. By drawing the attention of this court to the show cause notice, it is submitted that the government issued a show cause notice based upon a mass petition. Therein the question of internal subversion was not there. Chairman, vice chairman resigning was not there. Disclosed in the mass petition. Now we all know, my lords, how the panchayat in the municipalities were formed, what Balwant Mehra committee was, what Gandhiji vision was. It was because of that, my lords, that at the lowest level, there should be a democratically elected panchayat and municipality.
So,
that has to be
this
there.
486
Perhaps that is something that played in the mind of the court.
according to you, in 486, the very basis was that show cause notice was issued on the basis of a mass petition.
And nobody resigned there.
Yes.
Yes.
So
yes,
there was
yes.
no, according to you, there's an administrative vacuum.
In my case.
Yes. According to you, in your case, there's an administrative
Nothing has
vacuum.
happened based upon a mass petition or anything like that. Yes.
There's an administrative
yes.
vacuum.
Yes, that has
So
got
for-
created.
Yes. So that's the
Because of
best argument of yours.
Then,
is
my lords,
that-
11834. Second page. The name of the judgment was is Dinesh Shukla. Second page. Chairman of the Raghunath municipality, the letter concerned a mass petition received from the inhabitants.
Which one?
My lords, this one is 11834 of 2025. Dinesh Shukla.
11834. Yes.
Second page, my lords. First paragraph.
Yes.
The chairman of Raghunathpur municipality, the letter concerned a mass petition received from the inhabitants. Again, similar situation happening. Then, my lords, the next judgment. Ravi Shankar Das.
Ravi Shankar Das.
This, my lords, is 11873. Paragraph number 6. By drawing attention of this court to the show cause notice, that is such and such, it is submitted that the government issued the show cause notice based upon a mass petition dated such and such. These are all, my lords, litigations wherein, my lords, based upon maybe what played in the mind of the court was that based upon some external influences, the decisions has been taken. In my case, it is a case of internal subversion. The chairman and the vice chairman, they have committed shenanigans, and they have committed that shenanigan in such a manner that the authorities were left with no other option. Because as per the rules, my lord, there are in total 167 services that are to be provided, including civic services. And therefore, my lords, in the best interest, my lords, such a decision has been taken.
Yes.
My lordship.
Anything more, Mr. Mishra?
No, my lords, that's.
Milord, I will make it very short, Milord. I'll go
এই
to
conduct rules টা আছে, procedure and conduct and business rules. Mr. Why are you not giving these books? to
My
the-
lordship, this is a very
to the
costly
court?
book. With the kind of financial condition that I have, I could afford only one. And that is the truth.
Should have donated this book to the court. High court.
Today, I am not in such a financial condition.
My lord, the entire panel is looking towards him. For
Yes. Then
No, Mr. Shah was more generous.
Yeah. No, Mr.
He used to,
Don't compare.
Milord, he used to pressurize the departments and get the nodal officers of the department to bring 4 sets of books and bring it in the office. Excise,
this is,
GST,
this might be necessary,
municipality.
these rules. Can you not get it from your department?
You can
Lords, I
consult
will-
Mr. Shah how
I
to
will
do it.
ask, Mr.
আমাদের
Bhattacharya.
এখানে
No, no,
সত্যি
Mr.
নেই।
Shah can help you how to do it.
আমাদের এখানে নেই।
There is a way out.
এটা
There is a way
একটু
out.
দেখ-
There is a way out.
কেন এই rules গুলো তো এটা তো লাগবে সারা।
And Milord, the most importantly, Milord, the excise, education department and GST. They have the most
So
recent.
GST books.
No, no, Milord, they have a, for their internal consultation, a compilation of circulars, which is most important.
Yes, that's also in land department.
Land department.
Land
Is that the-
department.
No,
goes-
even in municipality and panchayat, there is a compendium
issued by the government.
by the government, more than 3,000 pages.
So why are you not getting that? You are holding the post, you can.
I
ask
will
your-
pass the buck to Mr. Bhattacharya. He is my AGP here. He needs to do that. He will do that. And otherwise, sure.
Yes, because if these are, it will be easier for you.
And nowadays, these cases will come very often.
Yes, Mr. Ghosh.
Milord, I'll make it very short.
How much time you will take?
Milord, not more than 10 minutes. 10 minutes. Milord, to rule 2A.
That conduct rules.
Conduct rules. Milord, all the answers is hidden in rule 2A.
দেখি বইটা দিন।
Milord, I'll just place it once more, Milord.
Rule 2A.
Rule 2A. Rule, Milord, 6 subclause 2A. Filling up of,
6?
yes, which your lordship has already considered. 6 subclause 2A.
Yes.
Milord, in case of any vacancy in the office of the chairman caused by resignation, within 7 days or soon thereafter as the case may be, but not later than 15 days of resignation by the chairman, comma, a meeting of the board of councillors shall be conveyed by the chairman, or on his failing to do so by the vice chairman within 7 days thereafter, or on his failing to do so by any 3 of the elected councillors within further 7 days thereafter, for acceptance of the resignation or otherwise. Such meeting shall be presided over by the chairman, or in his absence by the vice chairman, or in his absence by a councillor elected by the councillors present as president for that meeting only. I stop here. So, Milord, this gives a window of, Milord, first 15 days, thereafter 7 days, if the vice chairman is also not there, and thereafter another 7 days in the event chairman, vice chairman both are absent. Now, Milord takes the date when the chairman, vice chairman has resigned from Mr.
So
Mishra's
15
document.
plus 14.
15 plus 14, 29
29
days. So it has to be counted from 14th of June because 13th of June they had resigned.
Not 18th. Mr. Mishra
No, no.
said 18th.
They have resigned on 18th, and my understanding is it will be 15 plus 7, not 15 plus 7 plus 7.
No, says 18th of June.
18th of June, they have resigned.
Yes, if 18th of June, 15 plus 7 is 21.
Yes.
So what does the date go to?
Lords, if from 18th of June, Lords, 15 days would be
18th.
3rd of July, and from 3rd of July, 7 days would be 10th of July.
So how could you issue a notice on 30th of June?
Exactly. So, Milord, so Milord,
that tenure was still there.
Milord, let me
That
finish.
tenure was still there.
That is what I have
Milord.
seen, that when you are placing that, I have seen this.
When they received the notice, they could have immediately convened the meeting.
So,
That
Milord,
option was there with them.
That time, That is what I was telling you. That you are saying it was the casus omniscience.
No causes omniscience.
That is what I.
No causes
When you are placing that, I have read this.
So, Millard, the opinion.
So even if 15 plus 7, 21, if we take it, not 15 plus.
No,
14,
if Millard that, if Millard chairman and vice chairman, both of them are not there.
even
it
if
is-
we take Mr. Mishra's.
Yes, even then it
15
is
plus
21.
7. So it's 22.
22 days.
So 22 plus 18,
Yes,
it takes us to July.
July.
Cannot be 30th of June.
The show cause notice, I will explain. The show cause notice was issued when the first 15 days period has passed. Because what was expected was that the board of council will convene a meeting. That was also not done.
Yes, Mr. Ghosh.
So, Millard, on the date when the show cause was issued, the authorities were aware that the chairman and vice chairman has already resigned. Therefore, the third contemplation under section 6(2)(a) shall operate, which says 15 plus 7 plus 7. Now, the allegation that the board of councillors, Millard, has shown neglect or unwillingness to discharge their functions can only at the best can be presumed after expiry of this timeline, not before that. And Millard, the tenure of a municipality is not only protected by the statute, it is protected under Article 243U of the Constitution, which guarantees a 5 years tenure, unless dissolved by operation of law. Therefore, in case of dissolution, law has to be applied more cautiously.
Constitution
243U. Millard, kindly take 243U of the Constitution.
No, 243U has to be read with 243Q and 243ZF also then.
You'll be getting.
243U, dissolution of municipalities. I am only placing clause 1. But every municipality, unless sooner dissolved under any law for the time being in force, shall continue for 5 years from the date appointed for its first meeting, and no longer, provided that a municipality shall be given a reasonable opportunity of being heard before dissolution. So, except by operation of law, 5 years tenure is guaranteed by the Constitution. So, when you are applying a law of dissolution, you have to apply it very cautiously. And here, the opinion that, Millard, there was an allegation of gross neglect on the performance of the duties on the face of it is absent. From where do you form the opinion? And that is what, Millard, Honorable Justice Basu Chaudhary has held, that from the show cause as well as the order, there is no reflection that an opinion has been formed in a concrete form that yes, there was neglect in performance of the duties. And if my duty is seen to conduct a meeting, even the time frame for that has to be allowed. Thereafter, it may be followed up with the direction that unless you conduct a meeting in accordance with 6(2)(a), you are going to be dissolved. That opportunity has to be there. In hot haste, within 3 days, you are following a pattern throughout the state. In one municipality, you have one reason. In another municipality, you have one reason, and all in one pattern. Within 3 days, you are giving time and you are appointing an administrator. A elected body guaranteed by the Constitution, you are taking away the municipalities. This is, Millard, subject to correction, Millard, not permissible within the law, the limited that I understood, Millard. This has to, Millard, has to be set aside. The show cause as well as the order. That's all, Millard.
The 243.
And Millard, I'll just add, Millard, one thing, Millard, I just forgot to, Millard, point out. Millard, one judgment which I had placed, Justice Chondo's order, that, Millard, the dissolution order as well as, Millard, appointment of administrator was set aside merely on the ground that the board of councillors never had an opportunity to reply to the show cause. The chairman in his individual capacity had given a show cause.
But here opportunity was given to you.
Opportunity was given. Opportunity was given to us, but since the board of councillors was in limbo,
They have replied also. They have replied to show cause.
The councillors individually has
It's not
replied.
that you are not given any
And, yes.
chance to.
But
give a
in the
reply.
final order, Milord would see, in the final order records that no show cause has been received. So they have not considered or accepted that show cause also. The final order in our case, Milord, if Milord kindly takes the final order, there the records that there was no show cause.
They record.
3rd July 2026.
So yes, that is because you have not given to, I think, the appropriate authority.
No.
Board of councillors were asked for a reply by way of the show cause.
The executive officer served the show cause on us. We had submitted our reply to the executive officer.
Where is that?
Milord, page 29. The final order, 3rd July 2026. The 5th paragraph, last but one paragraph.
And failure to hold meeting.
No,
to
last
give
but
reply to the show cause.
yes.
Yes.
No,
And
there are
whereas-
various grounds.
Yes.
One is after tendering the resignation. So there are 4 grounds. One is tendering resignation. Second is failure to hold the meeting of the Board of Councillors. Third is to give reply. So
Yes.
it's not only one ground on which it was passed. First is tendering resignation. Second is
No, Milord,
failure to hold.
Milord, kindly cease. And whereas considering the situation prevailing in the Alipurduar
Yes.
municipality,
After
after tendering resignation of chairman and the vice
And-
chairman
and failure.
failure to hold meeting of board of councillors of the said municipality
Yes.
to give reply to the said show cause within the specified period. It can be stated that the board of councillors of the said municipality is not in a
Yes,
position to
not
carry
three,
out
two,
its
two,
functions.
two reasons.
Two reasons.
Yes, failure to, a failure to hold meeting to give reply. It
Yes.
should be and. So there are 3 reasons.
3 reasons.
Because one is 2 vital posts or persons holding 2
Resignation.
vital posts, they have tendered resignation.
Right.
So this, according to them, there's an administrative vacuum
Yes.
which has been
Yes.
created because these 2 persons holding these 2 posts are very important.
Very
posts.
important posts.
So you cannot
No
deny that. So tendering that resignation. Second is, according to the statute, you are obliged to hold meetings. Failure to hold meeting is the second one. Third is, you are given a show cause notice, you failed to reply. So
We
these
failed to
are the
reply.
3 grounds on which
Yes.
they were of the opinion that you have.
Board of councillors of the said municipality is not in a position to carry out its functions and provide civic services.
And to provide civic services.
The state government is of the opinion that the board of councillors of the said municipality has shown
And,
its incompetence.
On this, Mr. Mishra, only with regard to this documents, what are the documents which you have?
I wanted my lordship to go through the documents one by one.
Yes,
So the first one, my lords, is the chairman, she resigns.
yes.
She resigns of 18th of June 2026. Second page, the chairman writes a letter. He says that the vice chairman has resigned. Then on the third page, again 18 June, everything is happening on 18 June.
Yes.
On the third page, the chairman again writes a letter to the board of councillor. He says that in pursuance of 18.2, I hereby tender my resignation. I express my sincere gratitude, this and this and this. Then, on the fourth page, the executive officer of the Alipurduar municipality, he writes a letter to the chairman of the Alipurduar municipality. There is a request to him. He says that as per provision 6.2, a meeting of the board of councillors is to be convened by the chairman for acceptance of the resignation of the office. What does the board of councillors say? Does the next page, my lords? He doesn't do anything. He says, as per verbal declaration of the chairman, he is not willing to convene any meeting regarding his resignation. So not only that he has resigned, he will not even convene a meeting also. So that his resignation will never get ratified. Then, my lords, next page. This is to inform you that we are in receipt of official communication all to the municipality that the chairman and the vice chairman have submitted their resignation.
All right, I'm keeping it tomorrow.
All
right.
If it can be, Milord, slightly, Milord, slight precedence may be given, Milord, so that.
Yes, we'll be getting a precedent. Heard Mr. Mistro Lanet, Assistant Additional Advocate General. To stop, Mr. Ghosh Lanet, Advocate appearing for the petitioner, commences his submission in reply, but could not conclude due to paucity of time. To stop, list this matter tomorrow under the heading 4 orders. Yes.